gentlemen, it's 10 o'clock and it's now time to start our pre-application meeting for the conjoined inquiry into 3 Section 36 applications made under the 1989 Electricity Act, south of Daly and Straighton in South Ayrshire. The wind farms, just to recap, is 3 wind farms, Craiginmoddie, 14 turbines, 200 metres in height, and the reference that we've given them is WIN-370-4. The second wind farm, Carrick wind farm, 13 turbines, 200 metres in height, and the reference that we've given them is WIN-370-5. The third is Knockcronal, 9 turbines, 6 at 200 metres, 3 at 180 metres in height, and the DPA reference for that is 3706. So my name is Keith Bray. I'm one of the reporters appointed by Scottish ministers to consider these 3 applications. To my left is Mrs Leaven, and to my right is Mr Reid. Both reporters and myself will help out during today as we go through the agenda. All 3 of us have been appointed to consider these cases jointly and to hold a conjoined public inquiry. Our job is to report back to the Scottish ministers on these applications. The obvious advantage of having a conjoined inquiry is it allows an overview of the combined impacts to be considered together, and it avoids, hopefully, duplication of evidence. However, we don't underestimate the complexity involved with a conjoined inquiry, and there are 3 large proposals with and it may be difficult to find a timetable that suits everyone, so we understand there is complexity. In all Section 36 cases, it is ministers who decide whether or not to approve applications after consideration of our reports. For your information, we will produce 3 separate reports, 1 for each case, and will be joint signatories to those reports. So it's not one big report on the 3 wind farms, it's 3 separate reports that ministers will consider. In terms of today's proceedings, it's important to note that the meeting is being recorded. It's broadcast live. It's webcast for those watching elsewhere. And Callum, sitting in the corner, he's the most important person here today because he will make sure things run smoothly and ensure there are no technical hitches. Be aware that in due course the recording will be available on our website as an archive, and by participating today you're consenting to being filmed. The cameras track the speaker as we go through, so you will be filmed, and the images will be stored, used for training purposes and historical records, and those records could be made available to the public. So I'm just making you all aware of those matters. As I said, we'll come to introductions and we'll go round the table at the next item, but just remember and fill in the attendance sheet that's circulating. Housekeeping matters now. It's important that we switch off mobile phones or to silent, and anything else that you have in your bag that makes a big noise, please switch that off as well. If at any time you want me to speak up or slow down, or if you want to communicate amongst your team and you would like the meeting to pause for a minute or so, just let us know. If you have a personal emergency and you need to leave, just please leave. No need to announce that. In terms of emergency procedures in this building, there are no planned fire alarms today. So if you do hear a fire alarm, then I would ask you to make your way out the fire exits over both sides, and the muster point is at the rear in the corner of the car park. And if you muster there and talk to register with Mrs Leaven, that we've been told that that shouldn't happen today, but if it does, it's real, so please take that advice. If for any reason we have any emergency that we need a defib for, there's a defib located on the left-hand entrance as you go out there. So if we needed to use that, it's there. The reception is open all day if anyone needs to talk about the centre. The cafe, I understand, is open from 10 till 2, and it's accessible to you. You are allowed to bring drinks through, we've been told, so just so you're aware of that. Toilets just behind the cafe on the right-hand side, a fully accessible toilet on the left-hand side as you go out of this room. So we have extra masks if you need masks on a seat at the back there near the exit. So that's the general housekeeping matters to do with the centre. In terms of guidance on using these microphones, please don't lift them up by the stalk. Callum gets quite grumpy if that happens because they tend to break. So please don't lift them up by the stalk, lift them up by the base. If you want to speak, or you press the red button. There's only so many get to speak at once. So please, if the red light is on, then that should be you that's speaking, and that will direct the cameras as we go through. Generally speaking, you should consider being a metre apart as much as possible and wear a face covering when moving around the building. We haven't planned for a formal break. We'll just take breaks as we go along. Maybe after an hour we might take our first break, but there may be a need to take breaks as we go through today. We have allowed till 4 o'clock, but I don't expect us to be here till 4 o'clock, but that was just so that we could book the room just in case things are tricky in terms of finding dates and timetables. I would hope that we could be finished by 1 o'clock, but let's just wait and see how the discussion goes. It's important at this point to say that the meeting is about the arrangements for the inquiry and associated procedures necessary to conduct the inquiry for the 3 cases. It's not part of the inquiry, and we won't gather evidence today, so we won't be looking for opinions to be shared today. If we feel we're getting into a position where you're providing us with evidence, we'll stop you. And if we don't stop you, someone else in the room is likely to stop you. This is totally to talk about procedures today and how we go about arranging the inquiry. We've circulated an agenda. Hopefully you've all had that agenda before Christmas, I think. We've put extra copies out just in case on the table, so you should all have a copy. If you don't, can I just check just now if everyone's got copies? It looks as if no one's sticking their hands up, so that's good. You've all got the agenda. We'll try as much as possible to progress quickly through the various points. That won't always be the case. We will have to pause and have a discussion on the procedures, particularly in areas there is a disagreement on how we should proceed. But we'll try to rattle through things as quickly as we can. There are a number of parties, though, so you just have to kind of bear with us as we go through. If we need to pause quickly, for 5 minutes and gather our thoughts, then we'll do that and we'll let you know. And the webcasting will take a break then, and that will show online as a break in the meeting. And for every break, I will give you a time that we will come back, so that those watching online can come back at the appropriate time. Finally, as we go through the discussions today, the 3 of us will try to accurately pronounce local place names, but please don't go on to us too much. If we don't do that, we'll try and do it. But pick us up if we don't pronounce any place names properly. We'll try our best to do that, but we'll be advised by your good selves. So, before I go on to item 2, which is our introductions, is there any questions on what I have said so far? just look round the room, and there doesn't seem to be a hand or a light appearing, so that's good. So we can move on to item 2 on the agenda, and that's the introduction. We realise that some of the participants will only have an interest in one wind farm. Some will have an interest in more than one. So when you introduce yourself as we go round the table, please let us know which wind farm you have an interest in, just so that we can double check that against our list. Although there's a number of parties, we do wish to go round the whole table, just so everyone knows who we are. We have had apologies from Bar Community Council, but they have indicated in their email that they are still keen to participate as an opt-in party. So I get a chance to stop talking now, and I'm going to start with the introductions. And I'm just going to go to the applicants first, and Craiginmoddie.
Good morning. So my name is David Hardy, that's H-A-R-D-Y. I'm duly qualified, but for present purposes I'm a partner at Cameron McKenna. To my left, I've got Mr. Chris Calvert. He's the planning witness and an executive director with Pegasus. And then behind me, from the client, I've got Mr. Michael Briggs. So there's just the three of us present in the room. I don't know whether you want me to introduce witnesses who will be appearing later on in the actual sessions, but who are not in the room at the moment.
I think if we do that later on, that would be appropriate. If we stick to who's in the room.
Thank you.
Yes, good morning, sir. My name is Colin Innes, and I'm a partner in the law firm of Shepherd and Wedderburn. I appear on behalf of Scottish Power Renewables, and I'm instructed by Fiona Coyle, Divisional Solicitor, who's with me today, and I'm also accompanied by Kirsten Ray, who's the SPR Project Manager. In respect of the matters, I obviously appear on behalf of the applicants at Carrick. We did make written submissions in relation to the Craiginmoddie scheme, but not an objection. There were matters of technical clarification which we've raised, and we are obviously having ongoing dialogue with the applicants in relation to that. We did not make any representations in relation to the Knockcronal scheme. Thank you.
Excuse me, could I just check Fiona's surname and spelling? Thank you.
And for Knockcronal.
Good morning, sir. My name is Vincent Fraser, King's Counsel. I'm instructed by Pinsent Masons, and my instructing solicitor, Mr. Gary McGovern, sitting to my left, sir.
Thank you. I think we'll pop over to the council now, if you don't mind, and then we'll continue going around the room in an anti-clockwise direction.
Good morning, sir. My name is Douglas Armstrong. I'm King's Counsel and a member of the Faculty of Advocates in Scotland. And to my left is Nicholas Lopez, who is a principal planner at Stantec. And I'm instructed by South Ayrshire Council, who have objected to all three applications.
Good morning, sir. My name is Douglas Milne. I am a partner at Morton Fraser. I am instructed today by Nature Scott, and I'm accompanied by Ms Lindsay Kinnis, who sits to my left, and my colleague Cameron Gregg. Nature Scott have objected to the three applications on the basis of impact on the Merrick wildland area.
Good morning, sir. My name is Sarah Wardell. I'm a solicitor at Denton's, and I'm accompanied by my colleague Fiona McGregor. We act on behalf of Glasgow Prestwick Airport, who have an interest and have objected to all three wind farms being looked at today.
And for the community councils?
Good morning, sir. My name is Patrick Lorimer. I'm Chair of Crosshill, Strayton and Carrick Community Council. To my right, I have Gordon Ferry, who is Treasurer of the same council, and we have objected to all three of the applications.
I'm John Thompson. I'm Vice Chairman of the Galloway and Southern Ayrshire Biosphere Reserve. We've objected to the Carrick wind farm.
And if we just continue moving around the room.
I'm Ellen Trainer. I'm representing Daly Community Council. Apologies from the Secretary who's not available today.
I'm Susan Crothwaite and I'm representing Save Straighten for Scotland on noise.
My name is Christopher Shaw. To my left is Glenn Heggs. Behind me is John Ross. We are acting collectively for Save Straighten for Scotland in objecting to all three wind farms.
Okay, thank you very much for the introductions. I think that's everyone, as I understand it, that wants to participate has introduced themselves. An important point to make just now is that as we go through the discussions on the procedures, there may be scope, and you may find it in your organisation's interests, to group together with a party on a particular issue, perhaps. That's largely for the third parties in the room, that there may be an advantage to you in procedural terms to group together if you choose to do that, and we may discuss that as we're going through. Grouping together does help the efficient running of an inquiry process, so that's something for you to consider, not to agree on just now, but to consider as we go through our discussions. Is there any questions on the introductions? Is there anything anyone would like to say on what you've heard? Nope. I wasn't expecting anything anyway, so that's fine. Item 3 now on the agenda. And this, to a degree, is a bit of a listening exercise again, but we do need to go through this to explain that there are no detailed procedures for rules around the conduct of inquiries. However, we have produced a code of practice, which is the title for this agenda item, but it's modelled on the planning appeals regulations, and we'd expect to apply that code of practice in this conjoined case. If you haven't seen it, the document is available on our website, the DPA website, and we will put it in the note of this meeting as a web link, so you will be able to see it. The code essentially allows for a flexible approach. Each issue that requires some form of further procedure can be dealt with in the most appropriate way, the most appropriate method of examining that issue. That could be an inquiry, that could be a hearing, it could be requiring further written submissions. On some issues, there may be sufficient information already submitted, and we don't require further procedures. Having said that, when we write our reports to ministers, we'll take into account all of the environmental information that's been submitted, all the consultation responses, and all the letters of representations, not only the matters that were dealt with by the procedures through this inquiry. So all the information that's been submitted to date will be duly considered and reported to ministers. Also, it's probably important to flag up that the absence of any procedure on any particular issue doesn't give you an indication of the importance of a particular issue, or the reason why we're having an inquiry on something rather than a hearing doesn't lessen the importance. All we need to do is agree the most appropriate procedure for that issue. So for those who haven't taken part in an inquiry before, I know that many will have, but I am going to explain what a hearing and an inquiry is now. A hearing session is a structured discussion between the parties who want to be involved in that particular hearing issue. It will be led by one or more of the reporters. There's no formal leading of evidence, or cross-examination. We prepare an agenda for each of the hearing sessions in advance so that you're aware of that. Everyone who wants to participate can come along and sit round the table. There's no need for legal representation, although the parties' lawyers will no doubt take part. In advance of the hearing sessions, all participants would be expected, however, to prepare a hearing statement, and that would be focused in on the scope of the hearing. So hopefully that highlights what a hearing is. An inquiry is a slightly more formal procedure. Parties are invited to present evidence, and that will then be in turn be subject to cross-examination by those who have an opposing view. Usually parties are legally represented in an inquiry, and it's the lawyers who do the cross-examination. We as reporters will also ask questions as part of inquiry sessions, and they are more formal than hearings. They're suited for highly technical and intensive information. There's a lot of technical information. Their inquiries can be more suited, but hearings can equally be able to deal with technical evidence if it's not too extensive. Again, material is required ahead of an inquiry in order that all the parties see each other's case. A precognition, a summary of evidence is prepared along with normally a larger inquiry report, and all that is prepared in advance. There have been variations in inquiries in the past. Some individuals or groups who aren't legally represented or formally represented could prepare a statement and could be asked questions on that statement, but not necessarily cross-examined. So there are some variations that we could agree if it was suitable for this case. You'll see from our agenda, particularly Appendix 1, is that we've already set out what we think should be the case in terms of procedures, and we'll come on to that later. I think we start that under item 6. Site visits are part of the evidence gathering, and we'll talk about that as well under a separate item on the agenda. So that's a quick run through the types of procedures that could be employed, and that reflects the code of practice. Is there any general inquiries or questions after hearing those? Everyone generally happy with what a hearing and inquiry is and what further written submissions might be? Further written submissions are simply the reporters asking a party to respond and then allowing others to respond to that information. Everyone happy about procedures? Yep. Okay. We can move on now to item 4. And at this point, we would like to just give the applicants the opportunity, just in case there is anything that they would like to update us on in terms of updates. If there's anything in particular that you think is relevant in terms of your project, we'll just go round as before. I think we'll start with Craiginmoddie. Any particular update?
Yes, not very much. I think to report, there's an updated peat landslide study and a peat management plan. That is item 5A, but I'll deal with that now. That's just about finished and certainly will be available within 7 days. And it may be that it's felt appropriate to request that as being information required for the inquiry in terms of consultation. So that's coming. There are discussions between the respective landscape consultants, email correspondence. I think the suggestion unless I'm corrected, is that a cut-off date of the 9th of January would be assumed to look at the schemes, and then submission of updated cumulative material by the 1st of March. It may be that others want to comment, but that's my understanding of the email traffic between landscape consultants. Beyond that, there isn't anything else I think I need to say.
Those last two matters, there was a little bit of interference when you were talking on those last two matters. Could you recap those last two matters? Not the matter about Pete, but the subsequent matters.
I don't know whether that's because I'm too close to the microphone and too far away. Let me try again. So in relation to cumulative landscape issues, there has been discussion between the respective landscape consultants. And my understanding is that the suggested cut-off point, as in no further schemes to be taken into account other than those which exist on the 9th of January, and then submission of updated cumulative reports by the 1st of March. As I say, that's my understanding. It may be other people have got other things to say, but that's the email traffic that I have seen.
Thank you for that. That was a lot clearer this time. No interference. For Carrick, anything that you'd like to update the meeting?
Yes, sir. In terms of update, I think the updates really which might have a bearing on programming is probably fairly critical. And in that context, I'm going to start off with just an overview of aviation update, and then there is a matter which is pertinent to my particular application at 5B, which I'll again probably just address now if that's acceptable, sir. In terms of the aviation matters, we have ongoing discussions with NATS, and those are making meaningful progress, whereby it is anticipated that both there's a technical solution and that we will likely to reach agreement in relation to that matter. So very positive ongoing discussions arising in relation to that matter. In relation to Glasgow Prestwick, again, there have been ongoing discussions. In terms of that engagement with Glasgow, it is a staged process, and we're at an initial stage where we have to agree a framework for considering any further matters, and we've had quite detailed discussions about that initial stage, and if that were capable of resolution, would then be capable of going on to have a further discussion at stage 2. What I cannot give you at this stage is any guarantee as to the outcome of the more detailed discussion of the stage 2 approach, and against that background, I think it would be sensible in terms of the programming of this inquiry to ensure that appropriate time was set aside for dealing with, potentially dealing with the detail of that particular matter, and which forms the component part of the objection by Glasgow Prestwick. The third matter I wish to briefly update you on is the matter 5B, which is the ongoing engagement that my clients have had with SEPA relating to peak depth at a number of turbines. I can confirm that further work was undertaken prior to Christmas, and the initial results of that were available last week, and those are currently under consideration. In terms of outcomes, we're looking at 3 turbines in particular. 2 appear to be readily capable of a resolution, and hopefully that further work will have resolved the issue in relation to 2. In relation to 1, the outcome is less clear-cut, and in that context, if the ongoing discussions with SEPA, it may require the movement of one of the turbines. That's turbine 10, and it may need to be beyond the 50 metres that has been assessed in the environmental assessment, but not much more. I think we're talking, tens of metres beyond that particular level. If that were to require, then if we're required to do that, clearly we would need to submit an amended layout. We're probably going to have to submit the amended peak data anyway, because it is technical data, it's new evaluation. As you will probably be aware, in terms of the Electricity Works EIA Scotland regulations, any information provided by the developer, which in the opinion of the Scottish Ministers is substantive information about a matter to be included in an EIA, is additional information. So it is given an exceptionally broad definition. And so if that material is to be lodged, either it will have to be advertised and go through the process of Regulation 21, or if you requested that information for the purposes of the inquiry under Regulation 26, it then gets published as inquiry information. In terms of timescales to resolve the matter, we're very conscious of the need to resolve this particular matter swiftly, in the sense of ensuring that the material for the inquiry, because it would have a bearing if we were... we've had a preliminary look and we don't think it alters the assessment, but in terms of updating the cumulative material, clearly we would want to have that reflected in any updated cumulative landscape and visual material that was made available to the inquiry. And so we are therefore working as hard as we can and as quickly as we can to resolve what happens in relation to that turbine. But I think we'd need to have a cut-off, and we'd probably say the end of the month, if that's at all possible, to potentially resolve that matter and to come back to you where we sit in relation to it. That would afford time for that to be taken into account in the cumulative material. And I suppose the other general update is that in advance of this meeting, there have been ongoing discussions between the applicants to see where we can assist the inquiry in reducing the overlap. And so there are a whole range of activities that are anticipated, including trying to work up sets of conditions, working on landscape and visual matters, to try and coordinate to ensure that if we coordinate, we can hopefully reduce the burden on other people engaging rather than having 3 sets of material, trying to work through that effectively. So that's already happened, and there's already ongoing discussions with the Council in respect to a number of these matters as well. And we did pick that up from the advance notice of the PEM that in this type of inquiry should be of great assistance in reducing the scope of material and making it easier for everyone to access matters and ensure it's done on a consistent basis. So that, in terms of those activities, those are already being undertaken and are already proving productive in terms of approaches.
Thank you for that. I think we'll probably return to additional information, what may be requested or advertised at the next item, actually, on both of those points. We'll return to that, I think, just to have a little bit more discussion. But for just now, just allow Knockcronal to provide any updates to us.
I don't think we have any updates as such. I have some comments on the cumulative landscape assessment and also on 5C, but I don't know whether the way you just mentioned things, you want me to wait and hold off on that.
I think so, because I think I'm going to go through each item in item 5. There was one other matter which has been raised, it's actually raised by Knockcronal very recently, and that was with regard to any impacts that the National Planning Framework, NPF 4, would have for an inquiry programme. And just so you're all aware, the Knockcronal applicant provided a letter from Nature Scot which indicated for another inquiry process that Nature Scot's position may move depending on whether or not a National Planning Framework 4 is approved by Scottish ministers and subsequently adopted. So that is quite a significant matter in terms of an update. We would normally expect updates to policy, whether it's a local development plan matter, just to be filtered in to the statements that would come forward for hearings, for example. But that is a matter that may have a bit more bearing. So I was actually going to ask Nature Scot whether or not they wish to provide any particular update, given that we've seen that letter with regard to another wind farm not too far away, actually, in terms of the position. We're also aware that NPF4 has not been to Parliament yet. It may not be long before it's there, but we don't know what the outcome of that will be. But I just thought I would ask Nature Scott to give their position on that.
Yes, thank you, sir. This is a helpful opportunity to provide a bit of an update. The position does largely remain as stated in the letter to which you refer for the Clockery wind farm, but appreciate not everyone has seen that letter. Nature Scott's objections to the 3 applications, as I mentioned earlier, does relate solely to the impact of the proposals on the qualities of the Merrick wildland area. All of the proposals are located out with the wildland area, and it's Nature Scott's understanding that the revised draft National Planning Framework 4 is likely to be adopted sometime before this inquiry. I understand that NPF 4 is before Parliament perhaps tomorrow. Policy 4G of the revised draft is particularly relevant to Nature Scott's case, and Nature Scott is currently considering the implications of this policy for its approach to proposals which lie out with wildland areas but have impacts on those qualities. When NPF 4 is adopted, Nature Scott will confirm its position to the inquiry regarding these applications and clarify its participation in the inquiry process, and it will do that as soon as it is able to do so. There's nothing more that I can say today other than to comment that when we do come to discuss the timetable, Nature Scott is acutely aware of what I have just said by way of update. There is this degree of uncertainty hanging over Nature Scott's position, and I will want to be clear that in terms of setting the timetable, Nature Scott doesn't want to cause inconvenience to the inquiry process should its position ultimately be that it withdraws its objection, but it is too early to say if that will actually happen.
Thank you very much for that update. Just on the back of that update, I would perhaps seek agreement around the table at this point that we initiate further written submissions sort of exercise to gather that information from Nature Scott and their position, and then allow other parties to comment on that as soon as we can, so that we've got everyone's position on it, not just Nature Scott's, but all the parties' comments on that and its implications on programming, so we've got that. So if all parties are agreed to that, then we will have that written submissions in order to clarify the position and the implications, and then the implications for all the other parties and how that impacts on the programme. Everyone looks reasonably content with that, so we'll take a note of that. Thank you very much for the applicants for those updates. If there was anyone else who wanted to provide an update, then they could, if something has radically changed since you've made submissions. But this item is largely for the applicants to update progress on matters. And I'm looking around the room, and I'm not seeing anyone keen to chip in. So we'll just move on to item 5, and we're going to return to a couple of the points that have been made by Craiginmoddie and Carrick in a minute, but additional information in relation to the EIA regulations for Electricity Act matters. It's often required for inquiries, but it does have implications for inquiry timetables. We know there's been a separate sort of additional information provided, I think, by Craiginmoddie originally, so that's been publicly advertised and consulted upon. And we may make specific requests for additional information, and the applicants may choose, because of the nature of the information, to advertise that under the EIA regs and consult. Often it is the case that if a matter is critical to an inquiry process, then that means that things are put on hold. Often matters are sisted, which isn't in everyone's interest sometimes. There may also be matters which are important but peripheral perhaps to the main inquiry matters that can run in tandem even though they're being advertised. So it's not always the case that we need to sift matters, but I think we'll discuss some of those just in a second. We made a list, and it's on the agenda, and Craiginmoddie has just sort of given their position on item A, and it may well be the case that I come back to just now and just clarify whether it is going to be additional information that you will advertise. What your view on that is?
Sorry, I didn't catch that last.
That the additional information that you were preparing for Ironside Farah, responding to their comments, whether it was your view that that was additional information that required to be publicly advertised. That's what was stated, I think, in your position statement. So we were working on the basis that that would be information that would be publicly advertised as additional information.
Then, as I indicated, there's two ways of doing this, as you've just either it's advertised or it's requested as being information required for the inquiry as set out by Mr. Innes. I think we're relaxed about it. It's going to be available 7 days, so there is time to advertise. So, are really in your hands. If you are going to have a list of information that you request, that can be added to it. If not, and you prefer to leave it to the applicants, then we will advertise. I'm
going to look for your view, though, because I'm keen that you clarify what you understand the information to be. If we have to make a decision on it, so be it. But in your position statement, you did indicate that that would be publicly advertised. So I just want clarification if that is to be the case.
We are happy to advertise it.
So your plan is that you would advertise that as additional information?
Correct.
Yeah. Our take on that particular matter could be a matter that could run in parallel. And I just wondered if any parties had any issue with that, because normally, as I highlighted, that you would potentially assist and pause an inquiry process, but given the discrete nature of that information that I understand is responding to, principally responding to the matters raised in the Pete slide assessment, then I do think that could be a matter that could be publicly advertised in tandem with an inquiry programme, and I'll look perhaps to the applicants, the other applicants, to give me their thoughts on that. Does that sound reasonable from your point of view, being involved in this conjoined inquiry?
Colin, on behalf of Carrick, we would have absolutely no difficulty with that whatsoever. Thank you.
So we have no issue with it.
Yeah. And the Council?
We have no issue.
Okay. So we've clarified that part, so that's useful. For Carrick, you indicated the Pete probing information. Have you seem to not come to a conclusion yet whether or not it would amount to additional information that you would have to advertise. Obviously, it relates to a consultation response to SEPA. You might have indicated it might not change your assessment apart from one turbine. So it's your view on whether or not you see that as additional information that you would have to publicise or otherwise.
Thank you, sir. In terms of the regulations, it is undoubtedly additional information because it's so broadly phrased, and the peak depth is a fundamental part of an assessment process. So the fact that we've supplemented survey information in that nature, it's undoubtedly, as defined in the regulations, additional information, and therefore, if there was no public inquiry, it would have to be lodged and advertised. And the only question is, if it was requested, then there is obviously separate rules just to allow it to be published as part of the inquiry. But if being consistent, the Craiginmoddie applicants being asked to advertise their peat slide risk, we'd be in the same realms in relation to these matters. And as I say, the one knock-on effect is if there was any movement of turbine, that has a bearing on finalising the visual material that might be relevant. So that's why it is unlikely to give rise to different effects because of the very limited nature of the move. But I'm pretty sure that those involved would want the turbine location to be accurately depicted in relation to any of the cumulative visual material that were required to be updated for the purposes of the inquiry.
And how would you envisage that additional information on the cumulative assessment, and how would you envisage that as part of the process? I understand that you're not in a position to say whether it will actually require to be moved, that particular turbine, at the moment, but how do you see that playing out in terms of the provision of that additional information?
Well, in terms of the additional information, it would be restricted in my submission to the very specifics of that turbine movement, if it required to be moved, and also the underlying data, the peat probing that supported the position relative to the two turbines that wouldn't be moved, and in relation to any movement. So that the data would probably cover 3 turbines and 1 potential movement. We would not be at that stage updated. We would have a statement within that, because it is additional information, we'd have to give consideration as to whether other effects arose from the movement of the turbine. Our initial look at those matters does not give the view that there would be any change in assessment to any other topic chapters arising from that movement. So it would be very discrete. If it was additional information, it would be dealing with that one turbine move, and if there would probably be accompanied by a visualisation of where it would make a difference if there was a different visual. But apart from that, it would then be carried forward, if there was a different turbine location, into the cumulative material that was required to be updated.
And how do you see the submission of that amended layout playing out within the inquiry sort of programme?
Well, we would submit it as quickly as possible, and as I say, it's really as far as I understand, it is not an extension of infrastructure. It's actually a shortening of infrastructure. So, in essence, there's nothing that's going to increase in effect. It actually probably reduces the scale of effect in terms of various other effects. So, in that respect, I don't think it would be particularly extensive. I think the likelihood is it would be a relatively simple statement accompanied by a layout and accompanied by the peat information.
And would you anticipate the peat information and the layout information coming together at the same time?
Yes, it would be a single document that covered all those matters.
On that basis, then, I'm taking that you're saying that the likelihood is that you're not sure yet whether it would be published or not, or what's your take once you include the layout and the cumulative matters? Would that amount to additional information that you think should be publicised and advertised?
Yes, sir. I think because of the definition of additional information is so broad in terms of the Electricity Works EIA Scotland regulations, it almost encompasses anything that a developer puts in that is of any substantive information. And as I say, because we are putting in survey material, which is new, that by its nature would give rise to that. And equally, we have considered the original environmental statement with a micro-siting of 50 metres. If the new location went beyond 50 metres, we would therefore, it would have to be considered, because that's not considered in the original environmental statement. So we would need to demonstrate, or at least considered, whether it would give rise to any further significant effects. And that in itself means it likely to be a matter which could be considered substantive information relative to the regulations. So on any view, I think I've reached the conclusion that it is additional information that needs to be advertised or requested. And I think if in line of this type of nature, if a similar line is taken with the Pete slide, it's an advert, yes.
Thank you for that. We're likely to revisit some of those matters with regard to programming, but thank you for providing that clarity, and it may relate to other matters that we perhaps do request as additional information. Item C was flagged up by Knockcronal, not as a proposal but just as a possibility, I think, in their a position statement about an additional photo montage. So that it was just a quick a question as to whether that was a firm proposal or whether you would like to leave that to later on in the agenda, because you might see that we may be requesting information on cumulative impact from properties later on in the agenda. But if there was anything just now you wanted to add.
No, sir. We weren't envisaging this as being additional information. We thought it would be something you might be requesting for the purposes of the inquiry, and if you do that, we're happy to provide it.
For all the parties around the table, that comes up later on the agenda. A request, or a likely request, for additional photo montages with regard to properties. Now, item D, that's really in relation to aviation lighting schemes, and it may not be possible, obviously, to confirm at this stage the need for any further visual or cumulative assessments to be carried out, unless until there's aviation lighting schemes agreed. But do the applicants want to say anything on that just now, in terms of any lighting schemes, that if lighting schemes were to be agreed, what the implications would be for the assessment and any additional information that were to be provided on that basis? If we just go round the applicants, and we'll start with Craiginmoddie.
Yes, so an updated lighting scheme has been agreed with the city. So, so far as our scheme is concerned, we know which turbines will be lit. Now, we can obviously share that information. If other matters are going to be advertised, that can be advertised as well.
I think we'll go round all applicants first before we for Carrick.
Yes, thank you, sir. In terms of Carrick, we've proposed our particularly bespoke mitigation. We are asking our consultants to consider the cumulative position, but we don't have an answer to that yet. And that's to consider the circumstances where one or other of the schemes was also consented alongside Carrick, what aviation lighting might be required for that in a cumulative scenario. But as I say, the core of the Carrick mitigation is the Carrick mitigation which we've already put forward. This is only considering the cumulative scenario.
And from Knockcronal?
So there is an agreed lighting scheme which has a reduced impact. I think, if I've got my numbers right, so what you have at the moment shows 6 turbines lit, and the agreed scheme would be 4. I'm sure you're capable of imagining out the 2 that aren't lit, so to speak. But we are happy to provide. I think we are going to produce the visualisations with the agreed scheme. But again, we thought, sir, that probably could be simply done by way of requested additional information.
certainly when we've looked at it, that seemed to be information that we were going to ask for the purposes of the inquiry, given the kind of status of all the three schemes. So to cover all three schemes, we had envisaged that we would request a kind of update, which could be updates to the cumulative sort of assessments, but that would be us requesting that for the purpose of the inquiry, and that would be covered in our note of the meeting, and it would be set out as a kind of a procedure to follow. There may be a couple of unknowns in terms of some of the deadlines, but I think to fit in with whatever the agreed inquiry programme would be, I think that's our assessment. I don't know if any of the other parties want to chip in on that matter. No? Okay. Done.
I'm not sure, sir, if this is the appropriate point, but it covers a number of aspects. Save Straighten have quite a list of properties which we would like to be considered as part of the cumulative impact of all three wind farms. It comes under residential visual amenity, it comes under landscape and visual, and it also comes under site visits. So I'm really not sure at what point it's appropriate to raise it.
It's probably appropriate to raise it over the next three items, actually. You'll see that we have set out within the scope, that's in Appendix 1, with regard to residential amenity, we've set out a scope of properties that we would discuss today, requesting cumulative photomontages, I think. So I think at that point anyway, sir, discuss it, but there may be opportunities under the next item when we're discussing what type of procedures, whether we're going to have hearings or inquiries. So I think it would be appropriate to raise that then as well. So it's just as you see fit, sir, really. On the matter of E, which is... Sorry.
Also, a cumulative noise impact assessment is required, because there isn't a full cumulative noise impact assessment that shows the full range of the contours. They're all cut off in the figures in the applications. So I think that we're looking for some kind of full impact assessment extending to include Trelorg and Assal Valley, as well as the full Hadyard Hill, and also to include the noise impact assessment contour lines that extend beyond Desalloch.
Well, if I can actually ask you to raise that, and if I forget to pick that up under the next item, when we're going through the scope of potentially a hearing or an inquiry, that would be the appropriate point to make that in terms of what you think the appropriate scope would be. And we can discuss that, whether there's additional written submissions requested or whether or not we feel that's suitable for the scope, but we can discuss that just at the next item, if that's okay. Yeah. But if I do forget, remind me. The last item was E, which was cumulative baseline, and I think you indicated there seemed to be broad agreement that the 9th of January, which is yesterday, was the date. Now, again, we considered that, given that they've been conjoined and there are different timetables and different approaches taken, Craiginmoddie had been sort of created a little bit earlier, I feel like in the cumulative sort of programme, that we would request any updates that you provide for cumulative landscape and visual impact as for the purpose of the inquiry, so that all parties are happy with that date of the 9th of January. I'm glad you've come to that conclusion, but I'd like all the parties to get their view on that, as whether or not you'd be content that we requested, where necessary from the applicants, an updated cumulative assessment on landscape and visual matters. First of all, for the applicants, it seems that seems reasonable. I'm not seeing any lights coming on or any objections to that.
Yes, sir. I think the only thing is what we were trying to achieve by coordination is trying to streamline the material so that we don't end up with 3 sets of the same material, which is not sensible, not as accessible, and probably isn't that helpful. And if we can involve the Council in that as well, that we end up with an agreed set of material rather than 3 sets of the same material, which is really not really helpful, it's expensive and a bit of a waste. So that's really what the coordination was about. And equally, it would mean we would have a single set of material to work from, which would be a lot easier as well. So that was really the attempt at the coordination, and I think discussions are on the way about that, and that's why we need a cut-off so that we can start looking at that material and the preparation of it and the agreement around it.
Just to respond to that, it's unlikely that we'd be very specific about the nature of the detail. That would be left to yourself to do. It would just be an update on an agreed baseline as you saw fit. But perhaps I can come across to the Council now to see if there's any comment on that.
Sir, I'm not aware that the Council's instructed landscape witnesses have been involved in these discussions, and I'm certainly, it is not my understanding that a date has been, the dates of the 9th January and 1st March have been agreed with the Council. But these matters will no doubt be confirmed in due course. I certainly think it would be helpful if the Council's experts were involved, landscape experts were involved in these discussions sooner rather than later.
Yes, I think in the submissions it was clarified it was just agreed between the applicants, I think you said. But in principle, that a request was made because we are aware that the Craiginmoddie EIA hasn't caught up with all the schemes. So, in particular, there's perhaps a little bit more there, and you're nodding your head in agreement with that. So, it's really to just ensure that we're working on a common baseline. But in principle, does that sound reasonable that we would request that so that we've all got the most up-to-date information?
Yes, sir.
And Nature Scott.
Thank you, sir. Again, Nature Scott have not been involved in these discussions. I understand the explanation which has been given. And really, this is just to say that Nature Scott would be happy to provide its input as well, which might be helpful in terms of what is ultimately produced, and Nature Scott not at that point saying that they have any difficulties.
Now, for the other parties, this is just essentially so that each application will be assessed against a common baseline of other wind farms out there that are operational, consented, etc. So it's just so that everyone's talking from the same page. As I highlighted, one of the applicants was prepared theirs EIA earlier, therefore it hasn't caught up, and this should do that and then catch up with any other minor changes that may have happened or decisions even that might be made in the next few weeks, albeit we have got an indication that the 9th of January is the proposed agreed date, which I don't have a particular problem with. So any other submissions on that matter? We're happy to agree that as a request from the reporters on behalf of ministers for the purposes of the inquiry.
It's just the cut-off date is what I'm a little concerned about, sir, because obviously those preparing these have got to work on the basis of the information that they've got in front of them. And if we use a cut-off date of the 9th of January, they are effectively working as from today on the most up-to-date information. I just don't want people coming back later saying, oh, we should have included other things in that occurred later. So I'm envisaging you will set a cut-off date, will you, sir, in the request?
Unless there's any concern or any objection, we'd record that in the note the minute the 9th is the cut-off date that was agreed at this meeting. So long as the Council are content with that.
The only point I have is that obviously my landscape witnesses are not here today, and there is not an actual official of the Council here today. my understanding is that I don't think there has been any discussion with the Council's landscape witnesses in relation to a cut-off date, or indeed any date. If that could be a matter that we could perhaps reserve until I've got clarification of whether the 9th January is acceptable to for the Council's purposes, that would be helpful.
What we'll do then, we'll probably capture in the note that it was proposed the 9th, that it was generally accepted in principle, unless there's any good reason that it is flagged up, which is perhaps unlikely on what you've said. So unless there's very good exceptional reasons, then I think we should be moving on the 9th. It's simply to allow a date to be agreed for this inquiry process to move forward. And the 9th, given that we're having the meeting today and kick-starting that process, seems reasonable. So we'll capture that in the minute. Is there any other additional information out there that might appear? I think you've gone through your updates, and I don't think that there's anything else. Just in case there's any other party that thinks there should be additional information promised or should be coming forward, I don't think we're aware of any, but the applicants, there's no other additional information at this moment in time that we need to discuss. No. From the Council or Nature Scott, there's nothing that you've requested that hasn't appeared. Any other parties at the moment? No. Okay. Just to flag up is that if we proceed with an inquiry session, for example, on landscape and visual matters, if additional cumulative additional information is provided, we wouldn't necessarily, if we ask for that to be provided, we wouldn't necessarily ask for parties to comment on it. You'd be commenting on it through your submissions for the inquiry, so in your inquiry report and recognition. So we wouldn't envisage, if it's a matter that's subject to an inquiry or hearing process, that and we've requested the information as separate written submissions after the information is submitted, we would expect the parties to take that information into account in making their submissions for the inquiry through their inquiry report. That sounds like a mouthful. Is that clear enough for everyone, that we don't add in this additional process where we didn't need it? Okay, that's clear. We're also working on the basis that there's no other additional information or information that's been floating around between agencies that should have been additional information. So we will just work on the basis of that. And what we've discussed in this item at the moment may not have implications for the timing of an inquiry, but we might have to revisit that later on. Item 6, 7 and 8 are the chunky parts, and I was going to propose just now a little comfort break before we go into item 6. So if everyone's agreeable for a short break, then we'll do that. Everyone happy to come back at 25 past? Is that's long enough yet? 25 past sharp back here then, okay? Thank you. Okay, we can restart the meeting now, and we're on to agenda item 6. That's our provisional assessment of how the main issues could be addressed, and in particular those requiring further procedure. We may have quite a bit of discussion on this, but before we go into that discussion, I think it's important that I say again that all the written material that's been submitted to date will be taken into account. All representations and objections that have already been submitted will be taken into account, not just any any new material that comes through these procedures. Also useful to emphasise that that all parties who wish to be involved in inquiry sessions need to understand that they will need to prepare and submit evidence to allow other parties to see what evidence you have and to avoid any surprises on the day. Reporters don't like surprises, apart from at Christmas. Parties can rest on what they've said before, but generally speaking, you will be asked to present evidence in advance of the procedure. You're not required, just because a party has opted in to the inquiry process, it doesn't mean that you have to participate in every session. So we will likely agree a range of different procedures, inquiry sessions and hearing sessions today. You're not duty bound to attend any of them, and we will, in the next item, once we've agreed what procedures there are, find out which ones everyone wants to be involved in. So don't feel that you need to turn up at every procedure. And as I highlighted before, there may be an opportunity for groups to group together to allow their evidence to be heard, and that can be done on an individual topic basis. If two groups wanted to club together, for example, I think the Council and Nature Scot have highlighted that on wild land matters they may be working together. So if there's an opportunity on a single issue, you can group together just for a single issue and not everything. So just wanted to flag that up. The whole process is designed to be fair and open. Everyone should have the access to the same sort of information, and it's that information on which decisions would be made by ministers. Parties, it won't always happen, but parties should be prepared to take questions on any evidence that is put forward. That could be from the representatives or lawyers of other parties. So as long as you're prepared for that. We have set out in Appendix 1 in the agenda some topics for inquiry, some for hearings, and some for further written submissions. However, at this point, I would flag up that there was a level of email correspondence that we've received leading up to this PM last week, which was sent out hopefully to all parties yesterday via email. It was largely around different procedures and timetables submitted by the applicants, so hopefully you all received that email. The applicants and the Council on Nature Scot gave provisional thoughts on timetabling and indeed procedures. We certainly thought that everyone should see that. That's why the email was sent out yesterday. And in light of that correspondence, and taking into account our provisional assessment in Appendix 1 to the agenda, which looks like a table, just so you know, that's the first part of Appendix 1. We did set out our further thoughts, and that was that legal and policy matters could be dealt with by a joint hearing, that there seemed to be consensus that landscape and visual matters, wildland and aviation lighting in the round should be dealt through inquiry, probably allowing 2 weeks or so. As reflected in earlier submissions, time should be allowed for a joint session on aviation safety. Residential visual amenity, we were still of the view that that can be done through accompanied site visits and additional information that we would request.
regarding residential visual amenity, we would very much like to see an inquiry session on that, because we would like to cross-examine some of the people who have presented reports, etc., on that subject.
Well, thank you for that. Once I go through the scope document, then remind me of that proposal again, and it's likely that we discuss that and come to some conclusion, or allow us to go away and think about that a bit further and come to our conclusion. Thank you, sir.
Okay, I'd like to raise the same issue on the next noise and shadow flicker. We would also like to see that as an inquiry session rather than a hearing.
Thank you for that. So as indicated in the email sent out, at the moment our feeling is that noise and shadow flicker could be dealt with by a hearing. The same for traffic and access matters, private water supplies and planning conditions. So in all, we are suggesting that inquiry time may be best focused on aviation safety and landscape and visual matters, including wildland, and other matters could be dealt with by a hearing. So that's our provisional assessment. You've just heard their alternative proposals, which we'll discuss. The Council have also, I think it's fair for me to suggest here just now, that the Council have suggested that a specific hearing session be held on assessment against the landscape capacity study and other policy documents. I think that's in your submission, so that might be something that the Council want to propose as we go through our discussions. But before we come to a conclusion, I think it's important to state that any joint hearing sessions wouldn't preclude detailed consideration of site-specific matters on each application. It's likely that we would set out an agenda which would cover in detail all the matters that we are proposing to discuss. In a hearing session, you can question through ourselves the evidence of others. It's just not as formal as the inquiry process. And it certainly doesn't mean that cumulative matters wouldn't be discussed in a joint hearing session. Also, whether sessions would be held virtually or in person is something that we can agree later on as well. So that's an option. As well as that if the number of parties in a particular session is reduced, or we feel that there is scope for having a virtual session, whether that's to do with timetabling or something else, then it's likely that we would be looking for using a virtual process. It was thought today that for this meeting in particular, getting everyone together was important. A few more things before we go into the discussion. First thing is on statement of agreement. On certain matters, we would be expecting probably the applicant and the Council to, and potentially Nature Scott, setting out matters that they agree on. And that's largely going to be possibly around a legal policy context and landscape and visual matters. And the more we get into that statement of agreement, the better. And they're normally submitted in advance of the rest of the inquiry information. If anyone thinks there is scope for a statement of agreement on other matters, perhaps aviation, if we go to inquiry, then I think it will be useful that that's volunteered by the applicants or other parties. That if there are areas that can be agreed, it's often useful to prepare a statement of agreement in advance of the other evidence. And we'll discuss the timetabling of that later. Now we get on to the discussion on the procedures. We'll also touch on the further written submissions, but we've given an indication of what they'd be. It's likely that we'll flesh that out a little bit, and we might discuss that as we go through, but that was essentially a kind of summary as far as the further written submissions are concerned. I think we can go. We can go on to discussing the procedures. Is there broad agreement that the legal and policy framework can be dealt with by hearing? It seems from the correspondence that that's the case. Jointly, together, and a statement of agreement would be relevant for that. Is that all fair? I'm getting agreement all round the table, and that we may require to adjust the scope that we've set out there for the hearing, depending upon our further written submissions of National Planning Framework 4. So there might be a slight adjustment there, but we would set that out either in the note or at a further meeting. So I think
there's a question there, please.
Absolutely, sir.
Because as we made clear in our position statement, sorry, the Galloway and Southern Ayrshire Biosphere is not in a position to participate extensively in this inquiry, simply because we don't have the resources to do so. And the nature of our objection covers several aspects that you've identified in your list. But one that doesn't feature really in your list as such is actually the significance of the biosphere designation in itself. And it seems to us that probably the legal and policy framework would be the right place to discuss that. The biosphere isn't a planning designation as such, although it enjoys support in the Southern Ayrshire Council Local Development Plan, but it is obviously an international designation of some significance, and we are talking about, in the case of Carrick, a development within the buffer zone of the Biosphere Reserve, and we would like to be able to spell out the significance of that in the way that we did in the Clockery wind farm case, where it was done through a hearing session. So I think we'd be happy to do it there, and that may be the main place where we should be involved, given the limited resources at our disposal.
Thank you for that, sir. We don't have a particular problem with that. You'll note that on item 12 of the detailed scope under the National Heritage banner, if you like, we have proposed that we're going to ask a question or two just to clarify the status and implications of that designation. But I'm content to add that to the list of policy matters in the scope. And then it will be a matter for each individual group to present whatever evidence they think is appropriate for that hearing. And I don't see anyone around the room sort of objecting to that. It would just be a case of adding that. And that could be informed by our further written submissions that we'll come on to discuss it at item 12. So I'm happy to do that. Yeah. So that adds Biosphere Reserve onto the hearing scope for item 1, Legal and Policy Framework. And just to highlight, we are likely to amend and tweak the scope on the back of the discussion today. This is just our provisional, so it might not look exactly the same once you get it back. So we have one area of agreement that's good on policy matters. Mrs. Leaven is just reminding me of something that I should have raised, is that whether or not the Council would prefer the matter of assessment against landscape capacity study and other policies which you've highlighted to actually be more relevant to the policy session and add that to the scope of the hearing on policy matters.
So we were certainly thinking of that being in the inquiry session in relation to landscape and visual impact, and it would almost certainly come from one of our landscape and visual impact witnesses, Ms. Carol Anderson, who's been involved in a number of matters in relation to these issues.
Thanks. So you've clarified that you prefer that to deal with through an inquiry process. Does that applicants don't have anything to say on the back of that in terms of landscape and visual to add in assessment against the capacity study?
Sorry, sir. If it's going to be done, I think that's the time to do it in the landscape and visual session, effectively. Yes.
Okay. We'll add that to the scope unless any of the other parties want to say anything.
The only matter I was going to add, sir, is there are clearly some policy matters that reflect on these matters, and in particular the latest onshore wind policy statement, which has fairly clear statements on such matters. And it's just making sure that I'm presuming that that might well be a topic matter that is raised under the hearing session at the Legal and Policy Framework, and there might be elements of overlap on that particular aspect, but I understand the actual application of it to the particular documents might well be best served by landscape and visual witnesses, but there may be elements of policy which will also perhaps bear in the wider context of that policy discussion. So I just flag that there might be a bit of overlap there in terms of policy, and I don't want to say that it's purely an LVIA inquiry session issue, but equally I can understand that where the specifics of those particular matters that have been raised by the Council, they are likely to be ones that are the detail, etc., of the particular studies, but the overall framework in which they now sit, is the change policy context, which we'll address in our policy statement in any event. But I just say that I think there may be an element of overlap there, and we don't want to duplicate, but there may well be context that comes from the policy session for that material.
I think it may be useful to just adjust the scope of the policy session to include those matters, and then the detailed assessment through the inquiry. I think I'm getting nods round the table, so that's useful, and we'll adjust that scope. In terms of landscape and visual matters, we had proposed three discrete sessions, inquiry sessions. There seems to be a consensus that it may be better to have landscape and visual matters, impacts on wildland and aviation lighting together as part of the inquiry process. So perhaps we could have a discussion on that matter first, in terms of whether you feel there is sufficient merit in this case, notwithstanding the matters that Nature Scott have indicated earlier on, which may change matters. But do you see sense in combining all the landscape and visual matters together into one inquiry sort of process, if you like, albeit there might be different sort of sessions within it? But perhaps if I could go to the applicants first and then go round the table. So, Craiginmoddie.
I think that raises a number of sub-points, if I may. I'll make some general observations first. Clearly, primary responsibility is to assist you. The second point is that we take a different view to that which is expressed by Pinsent Masons in relation to desire to attend sessions which are specific to other schemes. So certainly from our perspective, we do not wish to attend or participate in sessions which involve other sites. The third thing is that we're very happy with virtual sessions, if that, or hybrid sessions. That's something you haven't mentioned, but hybrid sessions have been working well. And I think the fourth general observation, based on experience of a number of these co-joined inquiry sessions, is that there is benefit in having separation between schemes. I think there are dangers in mixing all schemes together within sessions. So they're general observations. If the question was, do I think that the aspects of landscapes of wildland, aviation, lighting can be combined? Yes. Do I think that all parties need to attend one sort of combined mega session on landscape? The answer to that is no. I think there ought to be a sequential approach, even if it's that the landscape sessions are to be heard consecutively within the envelope of that session. I think there ought to be separation between the schemes. You hear those separately, and then any genuine cumulative issues are dealt with at a session where all parties would be expected to attend. Now, that's not to say other parties may take the view that they want to sit through sessions which aren't specific to their scheme. That's a matter for them, but that's not the approach that we will take. So our minimum or our expectation would be those schemes dealing with Craiginmoddie on their own, landscape and visual, wildland and aviation lighting, and then any sweeping up cumulative points. I think the final point I would make on that, I had a brief discussion. We have had discussions outside of the inquiry, and it bleeds into a discussion about timetable. But leaving the dates aside, there's a question about how you would deal with cumulative issues, whether or not you would want Craiginmoddie to deal or to give its evidence in relation to cumulative aspects as part of the Craiginmoddie session. You would then ask Carrick to deal with its view on cumulative in its own session, or whether you would deal with solus effects for each of the schemes and then have, say, 2 or 3 days to deal with all parties' views on cumulative. So I think there's a question to ask about how you would want that ordered.
And your view on that particular matter is?
I think I'm easy, but it's subject, I think, to dates. That may be the driver. I don't know whether you want me to go on to order. Probably I don't want to go into dates just yet, but it does seem to me as a generalisation, those first 2 weeks in May.
I think we'll probably come on. I think we'll probably come on. It could confuse matters if we start talking about dates just now. Certainly from my mind, anyway.
So I'm not going to go to it, but just as an overview and listening to what the council had to say, you could have a legal and policy framework session to start with, including the parts of the position or the position statement at MPF, and then you could have a second day in relation to the policy aspects of the capacity study. So you start the inquiry with those 2 sessions, and then you go into the Craiginmoddie site-specific sessions. It seems to me that there's a logic to that order.
Well, we'll probably come back to that in terms of sequencing. But my question just now was probably more straightforward. Was it just, from the applicant's point of view, do you think that there is merit in, if you like, combining all landscape and visual matters together for an inquiry process in terms of your witnesses and such like? Is it sensible to hear evidence on landscape, visual, wildland and aviation within the broad scope of the same inquiry session, or to clearly separate them out?
Then the answer is yes, we are happy that they are combined. It's a long answer, but I hope that's given some useful background to the general approach.
And for Carrick?
Thank you, sir. In terms of an approach, I actually am in agreement with Mr. Hardy in the sense of suggesting that the best way of looking at a scheme is to look at the scheme individually in its context first. And my experience of conjoined inquiries, where that has occurred, is that each scheme is properly evaluated, and by the end of that, you have a full knowledge of that scheme. You do the 3 schemes, and then a cumulative session is held, which is usually relatively short, because actually the cumulative issues tend to be quite narrow and focused. In the context of these 3 schemes, each is objected to by the council individually. So the council's position is that each scheme is individually unacceptable. And against that background, it is quite important to test each individual scheme. The other aspect to this is if we combine everything, which I agree with in terms of evidence, I don't think having separate bits within the landscape and visual would work particularly well. But it does leave witnesses for the Council dealing with 3 schemes, 3 cross-examinations, etc., over an extended period of time. And that actually is often where I find the effectiveness of inquiry time is reduced by the fact that the witness is undergoing cross-examination over an extensive period of time over numerous topic issues. Whereas if we're quite specific about we're dealing with 1 scheme, 2nd scheme, 3rd scheme, my experience has been that the cross-examination is relatively limited, and that it would only really be in the cumulative that there would be the extended session of a witness potentially being cross-examined by 3 parties. That tends to be more focused by that time in the inquiry. And as I say, that's my experience of dealing with cumulative schemes, is that it is beneficial to understand the particulars of the individual scheme first before one comes to look at the cumulative. And it keeps it straightforward and it keeps it more focused. Whereas if we have a combined session for everything, everyone has to be present throughout, which, as I say, I said at the outset of this proposed meeting, that my clients have not made representations in relation to the other schemes, in relation to landscape and visual matters, and we do not have a position. We've not made representation. So, in that respect, we're perfectly content for the other parties to submit and present their evidence without us essentially having the ability to intervene, provided it's restricted to the topic that is canvassed within the particular session.
Thank you for that. Well, that's clear that you're quite content with grouping all the landscape and visual matters, and agree with the sequential hearing of the evidence in terms of the applications, which we would probably have envisaged anyway in terms of our experience. Knockcronal.
So can I preface my remarks with 2 comments? So we're happy to do, and obviously the most important thing is to do what you find the most useful for understanding each of the applications. So we're happy to do whatever you ultimately consider is the most useful for yourselves. So secondly, obviously a consideration is how long overall things might take doing it different ways. And those are 2 factors, I think, sir, that have to be kept in mind. To go to the specific question you asked, sir, which is really whether your issues 2, 3 and 4 should be dealt with separately or together. I have to say, sir, aviation lighting, I'm not sure really. I struggle in my own mind as to how that would be dealt separately. It obviously has an implication for wildland. It obviously has an implication for landscape and visual impacts. I'm not sure how it would be dealt with satisfactorily on its own, so to speak, because it fits so much into both of those, really, and it's the impacts on those, I think, is the concern. So with respect to landscape and visual impacts and wildland, whilst I can see that they are separate issues, a lot of the matters relating to them are common, it seems to me, and certainly we would certainly on our side be using the same witness for both of them. So that's why we're perfectly happy for them to be dealt with all in a combined way. But if it's more useful for you for looking at things, if you want them dealt with separately, that's fine. So we don't really mind. We're neutral on that. If you want me to move on then to the other wider issue, which is the way the matter's then programmed, i.e. whether we have separate sessions or whatever, I have to say, sir, it's my experience, certainly, that you're going to get a more efficient use of inquiry time if you simply follow one on from the other, and if they follow each other, because clearly, again, whilst there are, if we just take the landscape visual impacts, whilst there are obviously quite separate issues as to the individual impact of a particular proposal, a lot of the general matters are common, and so if you deal with them separately, so methodology, for example, is going to be common, and also other matters to do with the value of views and such matters. If you deal with them separately, I think you end up going over the same ground 3 times effectively, whereas if you're dealing with them in the more consecutive manner, it's likely that the persons who come second and third are going to end up having to say less on it than was said first time round. And that's why it seems to me you'd probably save inquiry time. And I think certainly looking at the way the programme worked, you would save inquiry time by doing it that way. And I suspect you might actually have a more concentrated approach on matters. The question that then arises, I think, which is also being asked, is if that is done, is the cumulative done as part of the individual party's case? So the individual party only comes once, so to speak, to give their evidence. And again, I'd have thought the answer to that would be yes, myself, if one's going to make the best use of inquiry time. I think that the third question that then arises is, does the council only give its evidence once, i.e. does it, so you basically just go through each party? And again, it seems to me that's the most efficient way of using inquiry time. So that you would deal with each of the applicants, I'm assuming, first, and they present their case. And they obviously are presenting their case in relation to their individual scheme. But you'd then have the council coming afterwards presenting its case about all three schemes. That I'd have thought would be the quickest way of dealing with matters. But if people disagree with me and you take a different view, so be it. But that's why we've expressed our views in the way we have.
Well, thank you for that. I mean, coming across to the council now, I think that there seems to be a degree of consensus to group items 2, 3 and 4 together and to treat the individual applications in sequence. But are you content with that grouping and anything else that you've heard?
So first of all, in relation to the grouping, yes, we're content with whatever approach you think is most appropriate in relation to that, and can certainly see considerable merit in grouping 2, 3 and 4 together. So we don't have any further points on that. We would also agree that, well, we've set out the council position in the email of the 6th of January, that we think it would be appropriate to deal with these in consequent, one after the other. We also think, though, that it would be appropriate for the council to give its evidence in relation to each one at the time that the applicant giving their evidence and the council giving evidence. We will be having different witnesses in relation to, there will certainly be 2 landscape witnesses giving evidence in relation to these matters. We also think that the most straightforward way, and appreciate that there are complex matters in relation to the cumulative impacts, but we think that that can be best dealt with in relation to each individual application at the time that that's being dealt with, and we can see the logic in progressing matters that way.
Thank you for that. From the council, which seemed broadly to agree with what the applicants put forward. Nature Scott, have you got anything to add?
Thank you, sir. Just in terms of Nature Scott's interest, just to make you aware that Nature Scott will lead 2 witnesses to deal with the wildland. Mr Armstrong has already referred to Ms Carol Anderson, who will be giving evidence on behalf of the Council regarding landscape and visual impact assessment. Ms Anderson will also be giving evidence on wildland area impacts for Nature Scott for 2 of the developments, and then there will be a further witness in respect of the Craiginmoddie development who will not be involved in broader LVIA issues. In common with everyone else, of course, Nature Scott will do what you find most helpful. That said, given the discrete interest Nature Scott has in the LVI session, it's understandably not hugely keen to have to sit through 10 days of evidence with the occasional wildland issue coming up. It would be convenient, and I simply state that as a matter of fact, as opposed to seeking to sway the procedure which is adopted. It does favour with someone else to have a discrete wildland session at the end of the LVIA session, because that would then focus the Nature Scott involvement. Principally mention that, not much in terms of convenience for Nature Scott, but the availability that they have, which will come on. I would certainly not want to create a problem in terms of programming, because Nature Scotland not available for the whole. Actually, be that in order to allow matters to run within the time available, actually work Nature Scot involved at the end of the LVI session.
Okay, thank you for that. It's important that we hear everyone's sort of views on those matters so that we can come to a conclusion, whether it's today or when we consider the note of the meeting. Is there anyone else who wants to come in at this point on landscape, visual matters, wildland and aviation lighting, and combining that into an inquiry session? Is there any concerns with that, sir?
I think so. We're very happy to go with what appears to be the flow, subject to we are very concerned that the cumulative impacts of all of this are really properly explored. I realise there are 3 separate developments, but they do constitute approximately 25 miles of wind farm construction, and the cumulative impact on that could well be very significantly different from the individual impact of the individual developments.
So from that, sir, are you suggesting that your preference would be that at the end of the process there's a discrete cumulative session within the inquiry, which has been discussed earlier, but is that what you're suggesting?
I think I'm reaffirming that that's what we feel would be a very good idea.
Any other contributions on the matter of landscape and visual matters? I mean, it does seem that there's reasonable consensus that we could group together, subject to Nature Scot's availability, and potentially even programming it so that you knew when you were appearing. But there does seem to be a groundswell support for combining all 3 matters together. But we will consider your point, I think, before we come to a conclusion on whether wildland should be separate. There certainly seems to be consensus that we deal with each individual application separately, including its cumulative impact. And I think the applicants had indicated that support for, if you like, a cumulative session at the end. I think it might have been described as a wash-up session by one of the representatives to deal with anything that arises that is best dealt with all 3 there. Now, I don't think that's necessarily supported by all the applicants, but it's certainly been discussed. We probably need to take that away and think whether that's reasonable or not. I think what we can probably say that in sequence, each application dealing with the sequential, the cumulative impacts is a given, and what we're to consider is the additional points from Nature Scot and yourself about whether there should be a separate cumulative session and whether or not there is merit in separating out wildland. I think that's where I've got to just now. Like you'll hear as we go through, we might not be able to come to definitive conclusions on these matters today, but by the time we put the note out, we will. So I would like to just touch a little bit. We will be expanding a little bit on the further written submissions for aviation lighting. I don't know if you want to go through every further written submission, but we will be trying to get, if you like, a picture of things. I don't know if Mrs. Leaven, if you want to add anything in terms of the further written submissions.
Sorry. Use the microphone, hopefully working. Obviously, there's a couple of items that were identified in the agenda, so and we've discussed it a little bit this morning already. And one of the issues was obviously with Carrick, currently doesn't have a lighting assessment. So depending on what comes out of the process of agreeing conditions, we need to bear that in mind, that there may need to be something else. We want to be clear ourselves whether all sites are suitable in principle for an ADLS in terms of proximity to the airports. what the likely timescales of schemes being agreed is. Obviously, you've mentioned that a little bit, but we'll really be pushing to know whether we can get these agreed in the short term, because that obviously leads into everything else. And the implementation, what's the sort of timescale for implementation of these schemes as well in terms of regulatory requirements? There's been a bit of discussion about that in the documentation, so that would be particularly useful to know for Craiginmoddie and Carrick. There was a sort of issue around just whether aviation lighting effects were considered to be landscape and visual effects, or just visual. There's slightly different approaches taken in the cases on that. I don't know whether consistency of methodology is necessary, but there is obviously a difference, so we would like to tease that out a little bit. And just a minor issue, I think Forestry and Land Scotland had suggested a number of 10 viewpoints for viewing the Dark Sky Park, and we wasn't aware of a map of those viewpoints having been provided. So that's something that we might request. Obviously, FLS is not here today, but I don't know if any of the parties have access to that, but we'll try and get hold of that if it's possible.
Yes, on that matter, we're probably writing to Forestry and Land Scotland on that matter, but that gives a flavour, if you like, for the further written submissions on aviation, which we'll kind of tidy up before the note goes out. But generally speaking, I think we've dealt with landscape and visual matters in terms of just how we want to do it, subject to the caveats on cumulative and those raised by Nature Scott. Can't promise anything, but we will consider these matters seriously before we actually come to a conclusion. In terms of item 5, which was aviation safety, we put there together a single bullet point there, which was more of a catch-all. Again, there'll be more detailed, specific matters that we write out to the parties on. And again, Mrs. Leaven, I don't know if you want to just give a general flavour for what those written submissions we're proposing would be. Yes, so on item 5, aviation safety, obviously we're aware that NATS is withdrawn on number 6, but Prestwick's still objecting to that case. So we obviously want to establish the latest position on all the cases, whether it's expected that we can actually get mitigation on the other cases. Just a second, I'll finish. Yep, okay. Prestwick, I think, was concerned about cumulative impact that was referred to in various responses, and we will obviously want to know whether that's been quantified, whether there's mitigation that's particularly required around that, whether there's anything that needs to end up in conditions in relation to that. And similarly, Prestwick had suggested that a detailed technical safeguarding assessment of the VHF-UHF systems may be required for each case. So we would want to understand whether that's something that is still required and whether it's required at this stage or whether it can be conditioned. So there's a little bit more detail that we'll be requesting on that. And we're anticipating on that would further written submissions exercise on aviation safety would be carried out in advance of the preparation of or the completion of the evidence. So you would have the outcomes of the written submissions and who we've asked to respond and who we've asked to respond to those responses, and carry that out in advance of the finalising the evidence for any inquiry. But moving on to the inquiry or the proposal for a potential inquiry session on aviation safety, from the correspondence that's been circulating around and what I've heard today so far, there seems to be consensus that inquiry time should be set aside for that at the moment. Is everyone in agreement with that? Craiginmoddie?
Yes, subject to the position in relation to release of the decision at Sanker/Clockery, and we suspect that they may have, or maybe definitive in relation to the positions taken either way. So yes, at the moment, and certainly from my client's position, that matter is going to stand up. So unless we're told something by the ministers in relation to those decisions, it is an inquiry session and it will fight.
Okay, obviously we can't comment on any other matters before ministers. Do you think that could potentially delay an inquiry session if there was let's say, evidence that you were awaiting? Do you think that could provide a delay to the potential inquiry session on aviation safety? Is that what you're suggesting?
No. So the case that I referred to, the case that I was involved in, Mr Emerson was involved in Clockery, but at Sanka, the issues which we expect to be brought at this inquiry were argued in full, and there were a number of points of principle, and they are likely to be determined one way or the other. And if we're told by the ministers that our interpretation wasn't right, then I suspect there would be a transaction done outside of the inquiry process. But it's not going to delay the case that we present here. We will carry on unless we are told that's not the right thing to do.
That's clear. Carrick?
Yes, I think it's very sensible to set some inquiry time down. I think the one matter that I was going to suggest, though, is it's probably too short. Just from prior experience in dealing with the aviation matters and the way in which they were presented, is that 3 days is not going to be sufficient, given the number of parties participating. I should say that Clockery was slightly different, and our position here is different from that at Clockery, and we're having our ongoing engagement with Glasgow Prestwick. So we're hopeful to try and actually have a narrower position before this inquiry than we had at Clockery. And in that context, we'll do everything we can to narrow what actually needs to be discussed. But again, even with the best will, that is a substantive issue, potentially, and it could last probably 5-6 days. I think I'll
say I agree with that. I think at Sanka the sessions lasted 5 days. I think they could have been run slightly more time efficiently, but I think it's 4 or 5 days.
Knockcronal?
Sorry, sir. We certainly think the time needs to be set aside for it. I think the difficult issue is just how long, really, because I think it still isn't entirely certain what objections will remain by the time we get to the inquiry, and how long will then be needed for them. So I think that's the difficulty we face in trying to stab in the dark, so to speak, how long you need. But.
And as we kind of alluded to, some of our further written submissions will try and get us to that point in advance of concluding evidence. But we'll take your point on the 5 days. Perhaps maybe Prestwick first. Any particular comments on what you've heard?
Thank you. Certainly in terms of further procedure, inquiry session is the way that Prestwick wish to proceed. Similarly, I suppose we have concerns regarding the duration perhaps being a little light. I think Sanka was 4.5 days, so we'd probably be looking 4 or 5 days as well.
Okay. Anything from the Council on that matter?
Sir, it's not anticipated that we will have a major degree of involvement in the session, and it sounds as though an inquiry procedure would be the most appropriate way forward.
Thanks for that. Any other party wish to chip in on aviation safety? So I think we're in agreement there, or there is agreement that a week should be held there, and that our further written submissions will be pursued to try and hone things down a bit, but inquiry time is set aside for that. Item 6, and this comes on to the point that was made earlier by those representing Safe Straighten, is that our view on our provisional view on residential visual amenity was that our consideration of the matter, together with the information that's been submitted already, could be dealt with by accompanied site visits to an agreed set of properties, but that we would require additional information for the purposes of the inquiry, particularly cumulative visual photomontages from the property, which are largely absent at the moment from those properties. I think it's 10 properties that we identified from the EIA assessment. So just to flag up or explain a little bit further what that would be is that the interested parties that have opted into this procedure who would wish to take part in those unaccompanied site visits would accompany us along with the applicants and the council, if required, to those, would set up a programme. We would often rely on either the applicants or others to try and fix that up with property owners, and that we would attend and be pointed out matters of interest at the site, and then together with fresh photomontages be able to come to a conclusion on our advice to ministers. That's our view, that would be the most appropriate procedure, rather than, sir, your proposal for an inquiry session, because what would be most important for us, I think, is that we visit the properties and that we have appropriate and sufficient visual information to make our assessment. And obviously it's clear that we think there's not at the moment. So that's just a bit of explanation as to where our bidding is coming in at the start, but that obviously requires a little bit of discussion. Potentially, I would ask the council just if they had any particular view on our proposed procedure for residential visual amenity.
The council's happy with that approach, sir.
Thank you, sir. And if I'll go to the applicants first, and then I'll come back to any other parties. So, just in the normal order, we'll go with Craiginmoddie first.
Yes, got nothing to add.
And Carrick?
Nothing to add, sir. Thank you.
And Knockcronal?
So we agree with your approach, sir.
Yeah, okay. Any other party? Sir?
I think our primary concern is that as things sit, you're going to have written submissions and accompanied site visits. Accompanied site visits are all very well, but there's no real opportunity for discussion at those, because individual members of the public living in those properties may wish to make their particular pitch about the effect that's going to be on their property, but actually they can't really have a private discussion with the reporters because the lawyers for the applicants will shut them down on the basis that this should be something which is put in front of everybody. So we would very much like to see either an inquiry session which would give us the opportunity to question the conclusions which have been reached by the applicants' supporting teams, because what you generally find with these situations is it works through a staged process of assessing the impact of a particular wind farm on that property, and then concludes that that impact will not be overwhelming. It doesn't really matter what goes before, playing devil's advocate, but it invariably concludes that actually it doesn't really cause a problem. So whatever way you structure this, whether it's an inquiry session or a hearing session, we would like the opportunity to question the people preparing that element of the environmental impact assessment. And we have, I should also say, a list of 10 or 12 additional properties which we would like you to consider visiting, because we consider that they will be affected.
Okay, well, I'll try and answer your points in turn. In terms of additional property owners. There may be property owners who have submitted representations and chosen to opt into the process. Then, because they've opted into the process, they have the opportunity to attend the accompanied site visits. Property owners are likely to appear there anyway because they may have given consent, I would hope, to a visit, and so it's only right that they're there. But it would be under the normal sort of accompanied site visits procedures, whereby we would simply ask to be pointed out matters of interest and not have a discussion. So you're correct in that respect. With regard to the having a session on an inquiry or hearing session on the EIA, it's our conclusion at the moment that having looked at the assessments, that the best procedure to actually make a judgment is visiting the properties itself, and we've got that list, which, apart from what you've said, seems to be broad agreement. I don't know if you could read out the list of properties so we can take a note, and what I can agree to do is, in advance of preparing and finalising the note of the meeting, we'll consider those properties. We'll go back to the assessments and consider whether our list is appropriate or not. But we were quite confident that was, if you like, the kind of baseline. But I don't know if you can read out the properties so that we can take a note, sir.
Okay, they're not in any particular order. The ones I've got here are Glen Gill, Little Garrock, that's Garroch. I can give you this list if you want. Wallerstown, Newlands, Tallominnock, Craigard and Dyke Cottage. We also suggest that as part of your site visits, you would look at Glentrool Village, which is going to be severely impacted by access to, I think it's Carrick, Nick of the Ballock, which is a national cycle route, which will also be impacted, and Edmonton Terrace in Daly.
I thought we were just focusing in there on the residential amenity. I mean, to be clear, we'll be visiting quite extensively across the area, not just the viewpoints, as part of our unaccompanied site visits. So if you can just keep the list to the residential amenity for just now.
Delete those last three then,
so,
because they're not properties.
Yeah, it's individual properties that
well, the others are all individual properties.
Yeah. 1, 2, 3, 4, 5, 6, 7, is that right? Yeah, yeah. Okay. Well, as I said, we'll undertake to consider those, but on the proviso that we'd be looking at the information that's already been submitted in order to come to that conclusion. On the matter of a hearing or an inquiry, I think I would probably open that up for further discussion to see what parties think before coming to any conclusion. The Council, you seem to be quite happy with what was proposed, but do you have anything additional to say, having heard?
Sir, we're happy with what is proposed, but we're not objecting to there being or saying that there shouldn't be an inquiry or a hearing session if you feel that or other parties feel that would be the most desirable way forward. But we think the way you've set out is the most appropriate way, but we accept that there can be arguments for either a hearing session or an inquiry session.
And for the applicants, for Craiginmoddie?
Yes, it would help us to understand if any of those properties, it suggested that Craiginmoddie affects any of those on that list. So I don't know through you whether I could ask that question.
Well, at the end of it, I was probably going to say that we'll probably do a little bit of correspondence in that to clarify those matters. I just wanted an initial list, but at the end of this item, I'd probably say there'll be a short written submissions, I think, to just to conclude. And it may be that the note of the meeting doesn't actually give you the absolute clarity that you require, and whether there have been visits to those. But we'll seek clarity in what and where the properties are, and what applications affect those properties.
So I wonder from past experience too, it might be useful if it's just possible for the third parties to identify on a map where the properties are, because I know sometimes properties go by different names and there can be confusion as to just which property is being referred to. So if it's possible for the applicants to actually identify on a map which ones they're talking about, would be helpful.
If everyone was content, we could actually communicate with Save Straighten quickly before the note went out, actually, and that might help. If everyone is content that our case officer consults on that and gets that information, and that information could be shared, whether we're able to do that before the note goes out, but ideally, if that's the case, that would be useful, and we could come to our conclusion. Anything additional to add from Carrick?
I think the only thing is seeking clarity as to whether, because what's being said is there might be a significant effect in that area, or whether the arguments being presented that it would fail the residential amenity threshold test. So I think obviously your residential amenity, visual amenity, is very much focused on that particular aspect, or whether it's wider comments about that. So as I say, these are matters, no doubt, that are best addressed by the people are putting forward. I think in that correspondence it would be helpful to see if that's what's being argued.
And anything additional from Knockcronal?
No, sir. We still are of the view that the method you propose for dealing with these matters is the most appropriate, sir.
Could I possibly just add to this, please?
Of course. Sorry, I was doing a bit of thinking
I think, judging by the number of actual properties that are involved in this, along the Girvan Valley in particular, that this is more than just individual properties that should be discussed here. I think we have residential, visual, amenity issues in the cumulative effect as well, which is why I think we need a hearing session at least is needed for this, to discuss following the site visits, because this affects a huge area overall, especially cumulatively. And as Mr. Innes referred, there are sort of points of law and residential amenity tests that should be discussed in greater detail than you can do on an actual site visit.
Certainly the matter we're discussing just now is narrowly focused on that residential amenity and not wider visual impacts, which would be part of the landscape and visual inquiry matters, which I think you're alluding to. This matter really deals with individual properties that may be significantly affected, that would impact the residential amenity of that property to a significant degree. So it's fairly focused. You'll have seen that each of the applicants has prepared a separate assessment of that. I was just keen to ask whether or not the applicants in particular felt there was scope with who you maybe have available to have a short hearing after the site visits on the day to allow that to happen. Would you have any objection to that? That may be able to address that matter, which has been raised by a number of It's just whether you think that would be possible or reasonable for Craiginmoddie.
I think, sir, it may be difficult to fit in a hearing along with the site visits on the same day. Would be the first point I'd raise on that.
Yeah.
I think the difficulty also, obviously, is if it's a hearing session, the parties might want more than just it's normally the landscape architect who will have gone around on the site visit. They may want more than just the landscape architect available at the hearing session. So.
Any further comments on that from any of the other two applicants, or do you agree with what Knockcronal have said?
I think it goes back to my question about to what extent the suggestion is that Craiginmoddie is having that impact. Otherwise, I agree with Mr. Fraser.
I think what we'll do just now is park that matter, because if there are other wider community matters that need to be addressed, then we may have a suggestion for that. So as we go through, we may return to whether or not we could have a particular procedure to address some of those community concerns wrapped up into one hearing session potentially.
I've just got one matter to raise, that for further procedures to be provided, and I fully understand the reasoning why, given the representations that you have, that you may want one, that it should actually take place before the site inspection, because the purpose of the site inspection is to view the evidence, and if you have it afterwards, it's a retrospect. And I do think that having proper notice of what the issues are and are being raised is beneficial to actually conducting the site inspection, whereas if you have a sort of I wish we'd been able to discuss this at the site inspection, it's a very different tone, and I do think that the site inspection should be informed by the evidence, not the other way around. So if there is to be a procedure, I would invite that it's done in advance, but fully understand the logic of the position that you've just advanced about some issues being considered.
Okay, thank you for that. So we're not dismissing that. What we're doing just now is just parking it for a few minutes, just in case something else appears through the discussion that we can work together on, because there may be other issues that the community feel requires procedures. The next item, which you've also got an interest in, is a proposal for a joint hearing. That's number 7, noise and shadow flicker. We would require some further written submissions up front, which we've set out there in the bullet point, which should be self-explanatory with regard to asking questions of the Council. I think there had been proposals earlier on in the discussion about an inquiry session. It's certainly our view that given the range of parties that may wish to participate in and the nature of the evidence we've seen to date, that it could be adequately dealt with by a hearing. That doesn't say that the hearing doesn't go into the specifics of it, and that the applicants and other parties will have their experts there that you can question, but it's just that you don't need to be legally represented as you would do in an inquiry process, and we just felt a hearing was a better option for all the parties. Do the applicants have any concern with having a hearing on noise and shadow flicker? The likelihood is that we'll consider each application and then cumulative matters as part of the hearing agenda. Craiginmoddie, any concerns?
No, we're content with the hearing. We think that's appropriate.
And Carrick?
Yes, sir. A hearing may well be the appropriate mechanism. I mean, the one matter is I've obviously dealt with Mrs. Cothwaite in relation to other inquiries where they've led quite substantive noise evidence, but it can be put in writing, it can be discussed at a hearing. So it's not a question of that evidence not being allowed in, it's a question of how that's discussed. So happy to, as I say, we think a hearing should be able to deal with the matters.
And Knockcronal?
We're certainly happy with that. Sort of standing aside for one moment too, so I thought that generally for this type of issue, it's probably more favourable to the third parties to have it dealt with by way of hearing, actually, than an inquiry session. But I just observed that, by the way. But we're happy with it, certainly the way you're proposing it, sir.
And the Council?
So we're happy for it to be by a hearing session because the Council's position is that these matters can be dealt with by conditions. We were just wondering, though, over the in the note, it is mentioned that and conditions that may be required. We're obviously going to have a conditions session, and there is a hope for agreement between the main parties in relation to the wording in relation to these conditions. I just wondered how that was going to fit in with having conditions part of this session as well.
Useful that we explain that for you. For the parties. It's really just more of a high-level discussion on the nature of the conditions required and not the detail of it, is whether these matters are capable of being dealt with by conditions and the style and nature of the conditions in broad terms, but not the detail of it. So that's what we had envisaged to test, if you like, the evidence on whether or not a condition could be applied rather than the detail of what the wording would be. Anyone else want to add? Yeah.
Yes, the reason that we would like to have it as an inquiry session is we would like the opportunity to cross-examine some of the noise impact assessment issues and results. We have got our own independent acoustician who is part of our witness, and so we wouldn't have the opportunity to cross-examine each of the different wind farms unless it was an inquiry session. It is a very technical issue, of course, as well.
Are there any other parties, perhaps the community council? I mean, is there any other support for an inquiry? We do believe that a hearing, although it's not formal cross-examination, you can still ask questions through ourselves, and we're unlikely to not allow you to ask questions, and their experts will be there along with yours. I've just felt that, given the nature of the evidence and the range of parties involved, that a hearing would be a more appropriate use of time. Should get roughly the same outcome. It was what our conclusion was, but I'm not sure if any of the community.
Yes, sir. I was going to come back in 6 as well, where I would support the request for a hearing. I think it's important for individuals in a community to feel their voice is being heard and being respected. I think in terms of importance and raising the esteem, I think a hearing would be very important for individuals who can feel overwhelmed when they're in the centre of a major initiative like this in their community. And having heard some of the detail from Safe Straighten for Scotland at a sort of a public meeting, I would support the idea of having an inquiry for the noise and shadow flicker, because I was certainly very taken by the expertise and level of knowledge that was presented at that public meeting. So I would support a hearing for 6 and an inquiry for 7.
I think we're probably going to have to take that matter away with us and just double check against the evidence and your submissions and our assessment, and come to a conclusion once we set that out in the note. But we've heard what you've asked for, and if we do think it's relevant, then we will provide that in the note. Can I just clarify, were you asking for an inquiry session on noise only?
Yes, on noise only.
Yes.
Yes.
Not shadow flicker.
Yes,
okay.
I mean we do have witnesses that that will be part of this. It just won't be myself, and the conditions, as the council said about the conditions. Once the conditions are set, it's very difficult to come back once the wind farm is built over conditions. We've seen this many, many times. So it is really important to look at the evidence submitted by the wind farms on noise from the point of view of the residents and the impact it could have on them.
Thank you for that. And just a footnote, if we do conclude that a hearing would be more appropriate, we'll certainly make sure that it involves the opportunity to ask questions of all parties. If we do conclude a hearing is the most appropriate way to deal with it. That's probably dealt with item 7. And you'll have to wait for our final conclusions in the note on that one. Item 8 is traffic and transport and access. We have proposed some further written submissions there. I think there may be a couple of additions. Mrs. Levin, would you want to add to the further written submissions under item 8?
Okay, so there was 3 items that were listed in the agenda under traffic, transport and access, and I think from our point of view there's a couple of additional things to that. So for Craiginmoddie, I think obviously there's different access routes identified, and we want to understand a bit more about which ones would be used and when, how would their use be controlled, and in the context of assessing any potential community effects, how and when the decision would be made on which route to use, option 1 or option 2 in terms of aggregates. So that would be helpful. For Knockcronal, I think it's suggested that it would not be possible to transport blade components through the Port of Ayr, but this is considered possible under Craiginmoddie, so I think we would want a little bit of clarity just on the constraints there, if there are any. And just a very minor issue on Knockcronal, I think it's a mix-up of drawings in Annex A and B of Chapter 12 that we can just double-check. So that's, generally speaking, what we'll be looking at around traffic and transport.
So that was just a little summary of the further written submissions that we would look for on that, and that would all feed into a hearing, and we've set out the scope for a hearing there. We haven't heard, I don't think, in correspondence anyone suggesting that that hearing wouldn't be appropriate, but...
Can I just ask a question, please? You just said that you wanted clarification for the Craiginmoddie proposal for access. Is that under the first bullet point there? Because that says 370-06.
There's different routes identified in both of those cases, I think. So we want clarity on what's happening in Craiginmoddie as well as what was in the agenda, which was about Knockcronal.
Thank you.
What we've set out in the bullet points was our initial assessment, and what Mrs. Levin has provided is additional matters to that we'll be writing out. So it's not just those that are at the bullet points. Mrs. Levin has just pointed out some additional matters that we'll be writing, and we'll capture that in the note. Are all parties, rather than going round the table, all parties content that a hearing is is the correct approach for this matter. I'm certainly seeing no all the way around the room, so that's useful. Well, on item 9, we considered that we need to carry out a limited amount of further written submissions on socio-economic tourism and recreation matters. We may require a little bit more clarity on recreational routes for Carrick. I think it's not clear. I think that would be a minor clarification. It wouldn't be additional information or anything like that. It's just a minor clarification over and above those 3 bullet points. So we hadn't identified any oral process for that, and I don't think leading up to this meeting there's been no request for oral information, oral procedure. But there is quite a lot of information submitted in representations and in the environmental information already. So I'm not seeing anyone moving anything different there. So 10 was grouping together hydrology, geology and hydrogeology to include peat, private water supplies and water courses. Generally speaking, further written submissions on most and a hearing on private water supplies. That hearing would talk about the generalities of impacts, but specifically on I think 3 properties that we've identified thus far as worthy of specific mention, and but that's not to exclude others depending upon the evidence that's put forward. So the oral process that we're suggesting there is a hearing with regard to private water supplies, and then at the very least looking at the specifics of those 3. Sorry, you raised your hand.
I don't question the hearing session. It's simply that 3 days ago every single pond and watercourse near my property was overflowing. A fortnight before that, they were all nearly dry. So we have this continuing trend, which I think has been noted by South Ayrshire Council, amongst others, for extreme weather. And I'd like to be sure that the assessments which have been made actually take account of what happens when water starts to flow in a completely different direction due to having 2.5 inches of rain in an hour and a half. It's just something I would like to see was covered.
You'll certainly be able to present whatever evidence you feel appropriate, and be able to question those within the hearing session on their evidence. So if you have evidence that you want to present as part of your hearing statement, then we would be likely to have a discussion around that and questions. So, but it may be up to yourself to present some additional evidence if you don't think the evidence is sufficient at the moment. But
I'd suggest that we actually need to have that issue addressed by the applicants, because as things stand, if these wind farms are not constructed, nothing happens. If they are, it may or may not, depending upon the expert opinion of their hydrologists, have an effect upon how surface water behaves or anything else. So I think it's actually a specific item which should be part of the environmental impact assessment. Historically, it never has been, because we've never really focused on this continuing trend which has been going on for 7 or 8 years now between drought and flood.
Just to reassure you a little bit, is that after a hearing process, once all the parties have presented their evidence, it's not unusual that further either additional information or further written submissions are made. So I think we would wait and hear your evidence at the hearing, allow the discussion and the questioning, and if at the end of the hearing process, for any reason we felt that there was additional information or further written submissions required, we may even ask that after the hearing process. So it's not always the case that the hearing process is the end of the matter. So if there was anything that we thought we needed to ask for, there is the possibility. So just want to reassure you on that matter. I'll not go into the detail of the further written submissions on peat or water courses unless you want me to, but that highlights the generality of what we'll be asking in further written submissions, and once we check the evidence, if there's anything else, we'll add that to the list. But the further written submission requests are generally quite specific. On cultural heritage...
So just before you leave private water supplies, it's the Council's position, as set out in our email, that there are complex matters involved here, and the Council's preference would be for an inquiry session, particularly in relation to the issues revolving around the Craiginmoddie application. The Council think that there would also be a considerable advantage in there being a specific site visit in relation to the private water supply issues, and that it would be helpful, depending on whether it's a hearing or an inquiry, no matter which process is eventually decided upon, it would be helpful to have that visit prior to the hearing or inquiry session. And so the Council's preference would be for an inquiry session in relation to Craiginmoddie, where they consider there are complex issues, and also consider that there should be a site visit in relation to the private water supply issues.
And with regard to that site visit proposal, is there specific sites? Is it a fairly focused site visit that you're talking about, to one or two properties, or to one or two general areas?
It would be to one or two general areas, yeah.
And in terms of inquiry session, is it solely focused on impact arising from Craiginmoddie?
It would be in relation to Craiginmoddie. In the relation to the Knockcronal issues, the Council's position is that they can be addressed by way of conditions.
I'll possibly turn to Craiginmoddie just to see if you've got anything to respond to what the Council has suggested.
No, we think it's a hearing rather than an inquiry, but I'll leave that for you.
The suggestion of a site visit?
We're relaxed about that. If that's thought to be helpful, yes.
Can I ask, if it was site visits were arranged for private water supplies, would they be accompanied? Would the homeowners be involved?
I'm assuming it would be accompanied, given it's a request for a site inspection, and the Council will be best to advise, but certainly that requires the consent of the landowner, property owner, and normally in these situations the property owner is often there, not always. Obviously all the parties that have opted into this process would have the option to go along to those site visits if we chose, but I don't know if the Council wants to add to what their intention was.
Thank you.
And obviously, if we're going on to private land, then you'd need permission of the landowners. We could prepare a list of the actual areas that we consider it would be appropriate to visit in relation to this site visit, and that might help. I'm sure we could do that within the next few days.
And if we were content to propose the site visits, would the Council be happy to coordinate all the elements required for that site visit to take effect?
Yes, sir.
It does seem to me that maybe mixing and matching inquiry processes for one. The general feeling I think we've got is that a hearing process may be the best way to pursue, given that the request for the inquiry is only really in relation to impacts on one application. I think we'll work as hard as we can to ensure that the allowance of time and the agenda is structured in such a way that there's a specific focus on the Council's interests with regard to Craiginmoddie. I think that's where we are at the moment, is that we'll make efforts to make sure that hearing process allows adequate time, and the agenda is structured in such a way that will allow ample questioning of the evidence. And unless anyone's got any particular concern about site visits, I'm quite happy to entertain that request from the Council. But Carrick.
Thank you, sir. Just to say that obviously if you were preparing an agenda, we would have no interest in this particular topic matter, and that's the way house segregation could possibly occur. It sounds like this might be take a substantive part of a hearing day if it were to put to the end the parties that didn't want to sit and listen to the issues related to private water supply could depart, if we're planning an agenda to make sure that not all of us are having to sit through all of the evidence. And I'd flag, if this was the start of the day, obviously I'd be sitting through half a day of evidence that really I wouldn't be contributing to at all. So
that's your bet for an early exit made, so we're hearing that. So I think we've got a conclusion there that we've come to through the discussion on that matter. 10. My apologies for not seeing you. It's just that you're far on the right-hand side there, so my apologies for that. But that was really useful discussion on that one. With regard to cultural heritage, I'm trying to move on so that we can move to lunch. We do have a couple of questions to ask of Historic Environment Scotland in terms of one monument, just to clarify, and we'll do that, and we'll give any applicants involved an opportunity to respond. There's a couple of further written submissions for national heritage, which we touched on before with regard to just asking questions about the biosphere reserve. So that set out there. There's likely to be a couple of questions on the matter of bats, just to clarify matters raised by Nature Scot and whether it's fully covered by the environmental assessment information. That's just to satisfy ourselves. Also on forestry, further written submissions just to get clarity on proposals for compensatory planting. Although we understand Knockcronal won't involve an awful lot depending upon access and such like. So that, before going into planning conditions, that really deals with the processes and procedures that we're going to follow in this inquiry. Before we go into planning conditions, I would just like to flag up perhaps, while the landscape and visual inquiry is, there could be a potential with all the experts around to have, if you like, a community hearing in an evening to allow those members who've opted into the process who might not choose to be actively involved in inquiry, but to be able to raise matters directly to us with the applicants present. It has been done in other cases, and it picks up on the point you're making about those maybe not being feeling comfortable to participate in an inquiry process. But that could uncover residential amenity, it could cover general landscape and visual matters, and it could cover wildland and aviation, and just allow, if you like, a slightly more informal session for those not wanting to be directly involved. And I think that might address the matter with regard to the call for an inquiry for residential immunity. If we actually had a session where you could question the applicants on the residential immunity evidence, we could potentially do that in a community hearing in the evening. I'm just trying to pick up an opportunity that all the experts might be there, and it has been done in other cases. And the applicants are they're not shaking their heads at me, so that looks reasonably positive. And we could structure that agenda to allow all types of, not just wildland and aviation and general landscape matters, but to include the residential immunity matters which you've raised.
Two observations, if I may. One is going to be a timetabling one, which is important. We'll come to that. The second, my experience, I'm not against an evening session. I think they're useful, but I do query the status of the evidence that's given in an evening. And I say that because some of those evening sessions, they're run as an opportunity for the community to have their say. But that is all there is. There's no questioning of those of community members, and I think that gives rise to difficulties about weight that you attach to what's said, because you're going to give more weight to material which is cross-examined upon, but it's difficult in those sessions for applicants to cross-examine members of the public, and it's a little bit self-defeating if the idea is for that session to be inclusive. So my experience of them is that they are useful, but as an opportunity for the community to have their say without the expectation of cross-examination either way. I think as soon as you allow members of the public to cross-examine experts, it puts you into a difficult territory.
Any other contributions before I kind of sum up on this particular matter?
Yes, sir. I mean, first point, should public participation to be facilitated? Yes. There's been a clear expression for that participation. So we would support finding a venue and an opportunity for that to occur. In terms of the process, in a Scottish context, it really is a hearing or a public inquiry or written subs. The hearing is a process chaired by the reporters. Through you, the members of the public can raise questions which then the applicants are asked to respond to. And I think that would work perfectly well. The expert's not been cross-examined, but they've sat listening to the particular point being made and is asked through the chair, if it's appropriate, for them to respond to that particular issue. I don't see any difficulty with that process. It is just a hearing in the evening and conducted to facilitate and ensure participation. So I don't foresee a difficulty. I think cross-examination in an informal way can be difficult, but there's nothing in the hearing process that doesn't allow issues to be directly raised, which are then having to be responded to by particular applicants in relation to material. So I don't think there's a void in the ability to effectively participate. It's just a question of direct cross-examination either has to be in a public inquiry or not, but in a hearing context, I've seen these work very effectively in an evening. The only thing, again, is having to timetable it so that people aren't participating all day and then turning up to perform in the evening as well. And I've done that, and it was, I can honestly say, by the end of it, it's the ability to participate, and attention span is limited in a day. So if your witness might have been giving evidence all day, to think that somebody can then come on and perform in the evening is actually very challenging. So some allowance would have to be made in terms of that participation. But as a matter of principle, we would support the concept of trying to find a way for these issues to be fairly and properly ventilated before you.
And Knockcronal?
I think we probably agree with what Mr Innes has been saying. So I think certainly cross-examination in a sort of a third-party session as you envisaged, a third-party evening session as you envisaged, I think might be problematic. I can see if it needs to be done, that it being done by way of a hearing session may have some advantages. I think I would just flag this point up, though, for the third parties and members of the public to consider, Either way, if they're wishing to do that, then they, of course, will have to produce their information beforehand too. It's not a case of turning up on the day just to sort of be asking questions out of the blue, so to speak. We would have to be receiving whatever it is they're saying so that the witnesses will have had the time to consider it beforehand.
Just on that final point, I mean, those who've opted into the process, for that type of thing, my understanding, we would notify them, and there's a possibility of notifying those who've made existing representations, so that you're all aware of what people have said. It wouldn't be a general public, sorry if I created that perception, that it would be open to the public, because this is an inquiry process. Those who've made representations to date have had the opportunity to opt into this inquiry process. I don't think we'd like to exclude those who've made representations, but it would be difficult to accommodate general public. I think it would be useful to allow the public in, as we would do today, but those participating would be those already have made representations, which there are quite a number. But just to be clear, it wouldn't be a general public participation, although the public could sit and hear, but it's those who've made representations to date that would be allowed to speak, if you like. So I just want to make that clear, and I think that addresses your point, that you'll have seen the evidence, or most of it, in advance, because the representations would have been made. Do you think, just on a final point, that is a reasonable proposition from the point of view of Save Straight and perhaps the community councils, that having something in the evening that is managed by the reporters but allows questioning of those who've made representations before is a reasonable suggestion in this, on landscape matters, landscape and visual matters?
Yes, sir. I think I could say on behalf of the Community Council, I think this is an excellent idea. It would be seen as inclusive. It would be increasing information to the people most affected. And I think it would be very much appreciated by the local community that they're being respected, aren't we? So I would think it's an excellent idea. I would support it, absolutely.
We would quite clearly set out the scope and how it will be run, so people know what they're expecting as well.
Yeah, I understand that, and I would also support that approach.
Yeah. Okay, and we'll take into account the timetabling matter. We'll not schedule it on a Friday evening, perhaps. Yeah, Mrs. Leedon.
I was just wondering, obviously Mr. Braid talked about it being an evening session, and I just wondered if there was any firm view that it was necessary to be an evening session. Would that cover more people that you think would be affected? Or obviously working patterns are different these days, an afternoon session might be possible. Is there any firm view of that, about whether it would need to be an evening?
I think I would just flag that. I think if you look at, off the top of my head, I think there are 4 community council areas involved across the 3 applications. It might be fraught with danger, quite frankly, in inviting the public even to attend, because there is quite a lot of strong feeling. Certainly a Friday night wouldn't be a good idea if they've all been down the pub, but in principle, it does touch on where we're coming from, because on the applicant's side, and to a degree the council side, Nature Scott, etc., they have got full-time employees whose day job is actually to devote themselves to these kind of matters. For the likes of us and the community councils, and indeed, I suppose, the biosphere, we're doing this in our spare time. And quite frankly, to find that time is extremely difficult. People who have a significant interest might well welcome an evening session because they're not at work, quite simply.
So it certainly sounds like an evening session would suit, for what I've heard, and I am conscious that the tummies might be rumbling at this point, but I am keen to get to the end of this matter. Planning conditions, we proposed further written submissions on those. Applicants in the council will be fairly familiar with that type of process, whereby we would probably look for a couple of iterations and get to a hearing whereby you're looking at what has been agreed and what is not agreed, and then what the reporters might not agree with, and discuss those matters, all bearing in mind the model conditions, which are still reasonably relevant, but have been tweaked and amended by various applications over the years, and come to a conclusion through a hearing process. There doesn't seem to be any dispute that that's the most appropriate sort of process for conditions. Sorry, Nature Scott.
Thank you. Really just to reserve Nature Scott's position. Obviously some of the conditions might have a bearing on Nature Scott's interests.
No, because we're talking about conditions, so that doesn't prejudge our conclusions on these applications, nor what ministers will consider. It's a standard part of the process. We try to reach what conditions may be appropriate if ministers were not of a view that applications should be approved. It's a standard part of the process, so it doesn't indicate view one way or t'other. All inquiries of this nature tend to talk about planning conditions, so I just wanted to kind of say that. I think probably that's it as far as conditions are concerned, and we've probably reached an appropriate where I think we read all the procedures, and we have to come back after lunch, I'm afraid, to discuss who's going to participate in each procedure, which I hope will be reasonably quick, and then talk about timetabling and the other matters on the agenda. So, if everyone's agreeable to come back at 2 o'clock, because time is running on. And the cafe does shut at 2 o'clock. I would highlight that. Okay, thank you, and we'll see you back at 2 o'clock. Let's make a start to the rest of the meeting. In case you lost track, we're on item 7, and this is where. Again, it might take a little bit of time, but we're going to ask who is going to participate in which procedure. We'll go through each inquiry and hearing procedure that we've just discussed before lunch, and we'll potentially touch on whether it would be in person or virtual as well. And I think Mrs. Leven's going to just give us a few notes before we go into going through each one. Mrs. Leven.
Thank you, and I have pulled this a little bit closer, so hopefully everyone can hear me better this afternoon. Sorry about that, and hopefully you've all done that. If you're speaking, it might need to be a little bit closer to you. So, yes, we're going to go through all the procedures here, and I think just to pick up on something Mr. Bray said there about virtual or in person, I think, Mr. Hardy, you referred to hybrid procedures this morning, but I think what we are really pushing for is either in person or virtual. Hybrid is quite a difficult technical thing for us to deliver at the moment. It makes it much simpler if it's either one or the other. So that's what you should bear in mind when we're going through this in terms of attendance. So, as Mr. Bray mentioned, not everyone needs to be involved in every oral session that we're having, every inquiry or hearing session, but we would like to go through them all and just identify quickly who's going to be involved. This is not specifically about dates at this point. We'll get to that just in a minute. I know you're all very excited about that, but if we could just quickly work out who's going to or want to be at each session. And then Possibly, as we're going along, if parties are able to say whether they can group together on a particular issue or topic, that would be really helpful. And obviously, if you do group together, then that lead person can then speak on behalf of the other parties or the individuals on the basis of any joint inquiry or hearing statement that you might prepare. So you could be working behind the scenes on that statement, but one person would then lead. So we understand, and hopefully that will be confirmed, that the Council and Nature Scot will work together on some issues. And we're also aware that the community councils and Save Straighten for Scotland, obviously you represent a number of local interests. So there may be scope for you to group together even further on certain issues, either on all issues or on particular issues. And we find that that will be maybe a more effective way for individuals to get involved, particularly because of the amount of time involved if we're thinking about, potentially a couple of weeks on landscape and visual. So that's something that you should really think about. And obviously all the sessions, whether they're virtual or in person, they will all be webcast. So anybody who wants to follow what's going on can do that. You wouldn't be able to interact in that way, but you would be able to observe and follow that. So we'll go back through items 1 to 14 now, hopefully a lot quicker than we did the first time, and then we might just need a quick short pause after that so that we can have a quick conflab, and then we'll go back about dates thereafter. So let us begin first with item 1, which was the policy and legal framework.
Okay, now I think there was broad agreement earlier on, or there wasn't disagreement that a day would be adequate. I'm assuming all three applicants would like to participate. I don't need to go around and ask you. The council would like to participate. Anyone else like to participate in the policy matters? Nature Scot are saying yes?
Yes, Nature Scot for their discreet interest, and I appreciate that we're not talking about dates, but just to remind myself, if nothing else, Nature Scot's availability for that session will depend on whether it's virtual or in person.
Yes, and the biosphere would like to participate, please.
Any other parties? Save Straighten. No other parties? Okay. Virtual or in person for that? I mean, there is scope, given that it's a limited amount of parties, potentially to do it as virtual, or are you agnostic on that matter? But applicants, any particular preference on virtual or in person?
Yes. I think ideally that ought to be in person, but it's subject to inevitably questions about timetabling. So what I've tried to do, and I have discussed, I've not had a chance to speak to the Council on Nature Scot, but looking at a potential... I think,
sorry to interrupt, but I'm trying to separate out the timetabling. We don't want procedures to be dependent upon timetable. We want the most appropriate procedure for... I mean, if there is agreement that we can do this virtually, then we should maybe try and agree that and then look to squeeze dates in, rather than working out the dates based on virtual or otherwise. Because if we can do a number of these virtually, then I think that would be our preference. But you've indicated that your preference is in person.
What I'm saying is that it's a very complex issue. Trying to fit in dates that are available, it would need to in-person sessions for Craiginmoddie would be the first 2 weeks in May. If it wasn't that, then virtual would be preferred. But if we can fit that in, there's another date, another week. I think it's the big week of the 29th. Again, that can be a physical session. So it depends on dates.
But your preference is?
In person.
In person. Carrick.
In person, thank you, sir.
So we don't have a very strong view, but I think it is in person, if you ask for our preference.
Okay. And the Council?
In person.
In person. Do we need to go further? Is in person? Okay, so that will have an impact on timetabling, but I think if...
Yeah, no, we don't need to come back.
I think everyone's agreed that in person is reasonable. Okay. Okay, we're not going to disagree with that. I think at this point in person one day, and we've recorded the parties, and no particular additional grouping there. On landscape and visual and wildland matters, grouping those matters together, 2, 3 and 4, including aviation lighting, there seemed to be broad agreement that around about 10 days might be required or so. Again, I probably don't need to go to the individual applicants. They will all want to attend, I'm sure, and the council will want to attend. Nature Scott, your attendance will be caveated by what you've said earlier on in your submissions, I suspect.
So, if I may, to attend for our session, but not to attend for anybody else's. So, if we're doing this in the agreed way, in sequence with the cumulative issues for, say, Craiginmoddie, it would just be attendance at that part of the block.
We'll be leaving that to your discretion, really. At the end of the day, we won't be requiring you not to attend. So,
yes.
Anyone else keen to be part of that inquiry? So, Safe Straighten. Community councils.
I can't really speak for community council members. Once the programme comes out, is it possible to opt in to certain days?
I think just now it would be better to say that you would be keen to participate. We will be putting a caveat out with the note to say that if there's any changes to those who have chosen to opt in or out of each procedure, you'll be given 7 days to do so. So the safest option just now would be to just say you'd attend and then you can opt out after that 7 days, if that's reasonable.
That's fine, yes. Okay. Thank you.
I was also going to say that to save time, I'm not going to ask you to rehearse who your witnesses are going to be. I think that might take too long. So if everyone's in agreement with that, we'll do that separately afterwards. I think that will just take up too much time. Everyone content with that? Yeah, okay. Do I need to ask if your preferences are for in-person and virtual on this one? It's perfectly possible to do a virtual inquiry session on landscape and visual, but applicants, any strong preference?
Like a stock record, it depends on days.
Okay. But your preference is?
In person.
In person. And for the council? In person, okay. Do I need to go further? Everyone wants to be together again. Right, that's lovely. Aviation safety. I think we've indicated, or there's broad agreement that it would probably require a week. So we just need to clarify who would wish to take part in that. And I'm assuming all 3 applicants would like to take part in that. Council?
So the Council's objection is primarily reliant on others, and it's essentially compliance with policy. At this stage, it would be the intention to take part in that, but we can that may change in due course.
And for Prestwick?
Yes.
Yes. Okay. And there may be other parties who are not here today who will take part in that, NATS in particular, and other parties will be given 7 days after the note to confirm that. Is there any other parties who would want to take part in the aviation safety inquiry sessions? Would anyone like to do these sessions virtually? There doesn't seem to be support for that. But
take a less strong view on this, probably physical, although at Sanka there were things like video sequences that the airport wanted to play, and that was very easily done in a virtual session. So I can see some benefits depending on the sort of material. It's not a strong view, but it was certainly useful to do it virtually.
It does look as if most of the participants are suggesting an in-person. And there are certainly nods around the table for that one. I'm sure we'll get one of the procedures to be virtual as we go through. Just want to deal with the residential amenity site visits. Not an oral process there, but is it fair to ask the applicants to work together to come out with a schedule and liaise with property owners or the council in order to pull together on the back of our note a schedule for that and organise the site visits? Yeah, okay. So we've got agreement that the applicants will team together in consultation with whoever they feel they need to, in particular the property owners. I think they're in liaising with property owners. I think you're wanting to just add something.
Can I just add, if property owners are contacting Knockcronal Farm, could you make me the point of contact rather than contacting them? Ellen Trainer at Dobbingstone. Thank you.
And that's in relation to making arrangements for the site visit. Thank you. And are we all confident that we could do that within a day? Just the site visits part of it. If we've got 10 properties, it may change if the property numbers change, obviously, but is there a degree of confidence on one day?
I think it will take more than one day if all the sites are included that Safe Straighten for Scotland suggest. It's a big area to cover.
From the council's perspective, do you have any sort of thoughts on whether a day, given there might be a little bit more daylight during May, I hope?
So we certainly thought that it could be manageable within a day. Obviously, it depends if you're wanting to go to the other properties, but the ones that had been discussed up until today, we thought that could be done in a day.
So would it be reasonable to leave it that if it stays at the 10 properties in a day, might be able to do it. If we expand the properties, then we should allow 2 days. Is that reasonable? Okay. And again, noise and shadow flicker, we had indicated a 1 day. We know we're to have a bit of a deliberation on the type of session, but want to understand. I'll have to go back actually. The residential amenity site visits. I just want to clarify who's going to be. All 3 applicants will be at those site visits, I assume. The council, would you like to be at the residential amenity site visits?
Yes, sir.
Yes. Now, any other parties? Safe Straighten. Okay, for Scotland. Okay.
I presume that the homeowners will be involved.
I assume the homeowners will be contacted and they'll be given that opportunity. It may well be that homeowners allow access but don't want to be there to kind of have oversight of what's happening around their property, but generally they would do. But they'd be participating on the same basis that, they'd actually just be participating on just allowing us onto their land unless they've made representations. But we couldn't exclude the property owner from their own property, no.
Thank you.
Sorry, I had to skip back there. So noise and shadow flicker a day, hopefully for an oral session. All 3 applicants, again, the council.
Sir, in light of your clarification about the condition being dealt with the conditions being dealt with in detail in the conditions session, then I don't think the Council would be intending to participate in that session.
Thank you for that clarification. Anyone else around the room keen to be involved?
Obviously, we'll be involved, and we would also like to each of the applications to be discussed separately and then cumulatively. And I'm not sure that a day will be enough. We will have a number of witnesses that will want to be part of this.
Would it be safer to allow 2 days in a broad programme at the moment? And is that your assessment, that it would be better to allow 2 days?
Yep.
Yeah. Okay. I think when we discuss programming, then we should potentially allow 2 days for that, with the proviso that obviously it might finish earlier than a full 2 days.
Can I add in Daily Community Council?
Yeah.
Please.
And is that sort of session suitable for a virtual oral session, either hearing or inquiry? And again, with the applicants,
I think we were more relaxed on this. We were happy to let you have your virtual sessions, but I mean, it's a matter for you, obviously.
yeah.
So.
I mean, our job is to, I suppose, listen to everyone today and make their case for it, and we'll consider all that and come to a conclusion in the note. But you're making a clear case there that it should be in person. And we'll take that into account before we make our final conclusion. But to allow 2 days within that, no option to group. The Community Council will want to join with anyone. You'll be making your own representation, your own evidence, and leading your own questions in that. Yeah, yeah, okay. In terms of traffic, transport and access, again, I think the 3 applicants would likely to attend. The Council?
Yes, the Council would be attending.
And any other parties keen to attend that session? Sir, from the Community Council?
Daily Community Council.
Yep. And Safe Straighten, yep. Is there options there to group it all, or do you think your representations are discreet enough that you'd rather to be represented individually?
I think we'd be quite specific. Crosshill Street and Carmichael issues we'd want to sort of address.
And is it possible to deliver that virtually? Is there any bar to the Community Council's attending virtually on that matter?
Could I add, just before you answer that, obviously just to remind you that we will be doing a lot of site visits around the area, and one suggestion that we had was that if there were particular areas that you wanted to direct us to on our unaccompanied site visits in relation to traffic and transport matters, then you could do that, which might allow us to have the discussion virtually.
And that's not necessarily to answer just now, but we'll capture that in the note to ask for that information. But it does potentially lead itself to a virtual hearing. That may be dependent upon availability, of course, but there's no strong. I don't think it's strong opposition to virtual if that was our option.
Daily Community Council would prefer if it's face-to-face and not virtual.
The private water supplies hearing, which we've discussed earlier on, There is potential, I think, to identify that as a virtual session, but we'll go round to the Council. I assume you would like to attend that session, as you've indicated earlier on.
Yes, sir, and just on the... that might be one that could work with a sort of virtual session.
And for the applicants who are going to be involved, attending, but no particular preference?
Yeah, happy with virtual. Yep.
Virtual. And any other parties, Save Straighten for Scotland, and any strong opposition for virtual?
Can I sign Daily Community Council up for that as well?
Yep, okay.
Do I have to register my interest for attending as an individual homeowner at this as well?
If you've made representations, which you may have had, which you may have done, and you've opted into the process anyway, then yes.
Can I go back and sign myself in for some of these sessions then?
What to do is, you'll see at the end of the note that you'll get is that everyone will be given 7 days. Right. This note will go to everyone, so you can reconfirm, no, I'd like to go to that. So I don't think we need to go through that. You can just do that yourself in the comfort of your living room, but within the 7 days. So there does look as if there is a possibility for virtual there, which may help with programming. There doesn't seem to be a strong preference. But the site visits do need to be in person. And can I just confirm who would be at that? Or would we be better to try and confirm participants once you've submitted the information on the detail of the site-specific matters?
I think that might be better, yes, doing it that way.
So if all the parties are happy, we'll capture that in the note and we'll ask those who want to participate to tell us once the Council have given us that information. Does that seem reasonable for the accompanied site inspections on private water supplies? Okay, I think we've captured that. Probably planning conditions next. Planning conditions are really interesting, if you want to just sit through a whole day and talk about them. We love them. And I'm assuming the applicants love them too, and we'll all participate. Excellent. And the Council? Nature Scott might, potentially. And Prestwick?
Glasgow participating there. Yeah.
Like to sit in. Are anyone else
we would
like to go through the conditions?
And Daily Community Council.
Daily Community Councils, okay. And again, given the topic, I think it's possible to do that virtually. Going through it, it may depend upon the nature and scope of agreement that has been reached, but I think we could start off with a virtual on conditions and then see where that takes us. If we need to go to in person because of the nature of the outstanding matters, then we can do that. But is there broad agreement for that? Okay, that's lovely. Well, it's good to know everyone likes planning conditions. Okay, so that actually probably takes us to the end of item 7.
Excuse me? Yeah.
Oh, sorry.
When you send out your note, will you have made a decision on 6, the residential visual amenity, whether you might be considering a hearing?
What I highlighted earlier on was that community hearing that we that I didn't mention that just now, going through all these procedures, but that would allow that to cover residential amenity as well. So the evening session that we talked about,
yes,
that could identify, could deal with that and general landscape and visual matters as well. So I think that's
fine.
That's what I understood from earlier on, and we'll set out in the note the details for that. We've had a good discussion on that earlier on, and we'll set out the scope and the arrangements for that. And it wouldn't be a general public meeting, but it would be a meeting that the public could come to, if you know what I mean. And we'll set out the arrangements in our note. Okay. we'll be leaving it open for other parties to come along to that evening meeting, but I think from earlier discussions, the applicants are all super keen to come along to that meeting, so that's useful. So item 8. We've pretty much covered, I think, virtual and in-person sessions. I think we know where we stand there. There's been a number of emails flying around availability and such like. And the Council, I think, recently, has clarified timetables for their for different hearing sessions. Safe Straighten have indicated that they prefer the proceedings after the end of May, I think, from memory. It's quite complex, but you know what procedures we've agreed, and we know roughly the number of days. And Mrs. Leven has had a number of coloured felt tip pens out on a diary and a calendar. Might give a quick overview, and then I think we're going to break and allow informal discussion to take place and to see if there's broad agreement. But I'll just allow Ms. Leven to give us a quick overview.
Okay, thank you. So, yeah, I've got my highlighter pens out and had a bit of fun colouring in, and as I'm sure you're aware, there are no dates that everybody can make. So we do have a slightly difficult situation that we'll have to have a little bit of flexibility around. What I don't seem to have yet is detailed dates from Knockcronal. We had some general discussion. I don't think I had detailed dates from you, but I did from the other two applicants. I did from Nature Scott and South Ayrshire. You've given us comments as well. And I think we had some from Safe Straighten too. So, I mean, a general comment on that is that there's sort of, if we're thinking about the core landscape and visual session, which is a couple of weeks worth, there's no sort of 2-week period where everybody is available for that either. Now, that may change. We don't know what Nature Scott's position is going to be going forward, but we have to assume at this point that Nature Scott is involved, so we need to find a way to make that work. And obviously, you've said on my left here that you may not want to participate in some of the sessions, but you may still want somebody to be at that session, you know, if you know what I mean. So we need to find dates that are going to suit everybody. So I don't know whether you've all done a similar exercise like that, and whether you're in a position to, if we have a short break, if you would be in a position to kind of have those discussions informally, maybe with the Council and Nature Scott, and see if we could come to some agreement.
Yes. I mean, I've put some dates together. I've not had a chance to speak to the Council on Nature Scotland. They're only being tentative on our side. But 2 points. One, the question is whether we would start with a legal and policy session on one day, and then have the sort of landscape policy session before going into the substantive landscape topic of Craiginmoddie, or we start with the Craiginmoddie landscape session. I think that's a discussion to be had. It matters not, given that the primary constraint that we've got is that the Craiginmoddie L&V, including cumulative, is dealt with in the first or second week of May. So either the week of, it's the second, third, 4th, 5th, 9th, 10th, 11th or 12th. So as long as that's dealt with, after that, our intention is then not to actively participate in those other sessions. We might have somebody listening in. And then the other point, and then the days are, I think, are slightly easier to slot in, particularly if they're virtual. The other block, which seems to be capable of agreement, certainly on our side, was aviation, which would be the week starting June the 20th, 21st, 22nd, 23rd, and then we might need a 5th day. So either we sat on the Monday, which would be the 19th, or we sat on Monday or the Tuesday of the following week, which is the 27th.
I mean, my initial thought there is that Nature Scott, that might be a problem to have the landscape and visual sessions so early on in May, because, well, we've got 1 week of their availability, the 8th of May, but then not again until the weeks of the 12th and the 19th of June, I think. So that is going to be a problem, potentially.
Fast moving update. Nature Scott, you're right, ma'am. 8th May, they're free that week, and that's the first week they are available. They're also available the week of the 15th May, which might help.
Not available that week, but we are obviously available the week of the 8th.
Sorry, can I just check, because I think originally the request was to look from the 8th of May. Is the case that Nature Scott are not available the week starting the 2nd of May? Or has that not been checked?
They're not available.
Well, to come back on the question of a policy session first or last, a number of the participants here will have been involved in inquiries and they'll have been dealt with in different ways. I don't think in our discussions the supporters have got a strong preference, and it may be that timetabling could influence where the policy matters were discussed. We've been involved in sessions where it comes at the end or at the beginning. If there's a strong preference between the parties, then we'll take that on board.
I think it depends if Craiginmoddie is going to start on the 2nd in that first week in May. If we're starting on the 8th, because of the unavailability after that, we'd need to get Craiginmoddie done. And so those 4 days I think we would use for landscape, preferably, and then seek to do the policy session later on.
Could I just double check, is Nature Scott available virtually in the first week of June if we were to try and do a policy session virtually to then allow the in-person landscape and visual to start the following week?
What we're actually going to do is we're going to leave the room now, and because we could be here all day going back and forward, and it's likely we're going to be here till 4 o'clock by the looks of things. If you think it's reasonable, I think there's scope for informal discussion between the applicants, the council, Nature Scott, potentially saves straighten because you've identified a constraint, but particularly amongst the applicants and the council, to come up with, if you can agree anything today, then we're going to ask you to try and agree that. If not, we'll be asking for you to re-clarify your availability and we'll impose it. So that's the kind of options that we've got. So we're going to try and get the parties to agree to dates for the oral procedures that we've identified, including the site visit dates for residential amenity and private water supply, those dates as well. Try to get those agreed as much as we can. If not, we will, through the note of the meeting, ask the parties to re-clarify their position and we'll impose the dates. And that always doesn't work if we impose things. So we'd rather that you come to some broad agreement and maybe give us a little bit of wriggle room around the fringes to play with things. But if you could try, if we break for maybe 20 minutes or so, do you think that'll be enough to try and amalgamate diaries together and try to come together with a conclusion?
Can I ask a question again, whether or not the week of starting the 2nd would be available for something, even if Nature Scott can't do that? Is that to be factored in? It would certainly give more flexibility if it was.
Yes, I'm just a little bit nervous that some of the things we've talked about earlier on, it's going to be very tight in terms of the timetabling. By the time you get through further written submissions, additional information that we're going to request, additional information that might be publicised in parallel. It's quite tight. I think you should consider that. I think we looked at in a note to say May and June, come together with your availability in May and June, so look towards that. But I'm just a little bit concerned that if we start bringing things too early, it might start to run into timetabling problems in terms of getting all the procedures done in advance and submission of evidence and such like.
I think it just unlocks things, that's all.
Yeah. So yes is the short answer. Okay, so can we leave you all for 20 minutes and we'll come back at 3 o'clock. The applicants in particular, the Council and Nature Scott, to remain in the room and try to address the timetables.
I'm really sorry, but I have to go to a funeral now, so I'll have to leave. But I'll just reiterate that I and my team on noise are not available until after the 29th of May, but after that we're very flexible.
Is it solely on noise that constraint is there?
Well, it includes the site visits as well and the other things that we're involved in. I'm afraid that we all have commitments that we can't get out of at that time.
But it's primarily noise in relation to...
and residential amenity and the site visits, and obviously the conditions come into that as well.
So your availability after the 29th is noise, site visits and conditions. Okay, right, I think that's clear. Okay, can we allow a break then of 20 minutes and we'll see what you come up with in 20 minutes. Thank you. Okay, we've had our short break and the parties have used that, I think, productively to discuss timetabling. I think there's a spokesperson that's been unofficially appointed.
Yes, reluctantly, but I'll take the job. So, it's not perfect, but it's, I think, as good as we're going to get. So, starting then on the 9th, 10th, 11th and 12th with Craiginmoddie Landscape and Visual. May. So, May 9th, 10th, 11th and 12th, Craiginmoddie, that's landscape and visual. Nature Scott are available. So that's the solus and cumulative effects for Craiginmoddie. Carrick then the following week, 16th, 17th, 18th, 19th. We then have a break, noise on the 30th. So that's noise and shadow flicker, allowing 2 days, 30th and 31st of May. Planning on the 1st of June. Planning policy, yes, legal and policy framework on the 1st of June. Then water, site visit on the 5th, virtual hearing on the 7th, transport virtual hearing on the 8th, then Knockcronal, the 12th, 13th, 14th and 15th, with a slight change to the discussion, a virtual session on landscape policy on the 19th of June, a virtual session on conditions on the 20th of June.
Can I just, sorry to stop you there, but I didn't get the impression that we had agreed a separate landscape policy session earlier on. Was that in relation to what the Council had said?
Yes, it's the Council. It's the Council's suggestion.
Because, sorry, just on that, it was in relation to the landscape wind capacity study and the South Ayrshire local landscape designations review and its compliance with guidance. It was that session that we suggested in our email of the 9th June. Excuse me, that could go ahead on the 19th of June.
Was that a separate session involving all three parties? And
yes.
Are the applicants agreeable to that? I think at this stage of the day, then we're not going to be knocking back on that one, but I assume that's is that a hearing session?
Heard virtually, whether that's hearing or inquiry, I think is a matter for you. It's really the council's request. I've just put it in the time.
So it's in the timetable, and we'll take that into account.
Take a view.
In concluding that, I'm happy with that.
And then virtual session on conditions on the 20th, and then aviation in the week of the 26th. So the 26th, 27th, 28th, 29th and 30th, that's starting on the Monday. That, I think, that's everything. So the only things that are not included there are a community session, if that's to be had. Otherwise, I think that is it.
Well, first of all, can I thank all the parties, and particularly yourself, for pulling that together. It's much appreciated and far more effective than trying to do it across the room. There seems to be agreement on those dates all the way around the table. Knockcronal?
Yeah, sorry, can I just raise 2 points there? I think you're going to go away and think about it anyway, but I have to say I didn't think we had agreed that there was going to be a separate landscape policy session, for want of as a shorthand term. I thought what we'd said was it would be swept up both in the landscape and visual impact part of the inquiry and insofar as there was a policy issue in the planning policy one. But I think you're going to take that away.
That was my understanding from earlier on in the morning, but we will take that away and consider, at the very least, we have a date in case our conclusion is that it is required. So that is useful. And just a small matter with respect to Knockcronal. Knockcronal, I think, is being programmed for 4 days. I think the way it's been put to you by Mr. Hardy is the 12th to the 16th. And the 12th is a Monday, so I think if you prefer to have it the 13th to the 17th.
That's my mistake.
Sorry, the 12th to the 16th is 5 days. If it was for 4 days, I think obviously it could start on the 13th. I think at the moment the whole of that week is free, so you can program it as you want effectively.
If you're requesting the 13th, I think we can take that on board. Yeah, okay. I don't think there's anyone around the table objecting to that. We do have to try and fit in a site visits for residential amenity, and are all the parties happy that we take all those other dates away and try to fit it in, or can we agree dates just now that would help that? 1 day with the proviso it may stretch to 2 for residential visual amenity.
If I could just add to that, just to reiterate that Save Straighten for Scotland, I think the lady who's left the meeting now, she had emphasised that she wouldn't be available until after the 29th of May, so it would look like probably June dates for those residential amenity site visits, if that's possible.
Looking at the dates I've given you, the 30th was noise, 31st shadow flicker, 1st was planning or the legal framework. So would that leave the 2nd? Is that the Friday? So that's a potential for site visits.
We can't do the 2nd. The one thing that does occur to me, I wonder, sir, if you're already going to be doing site visits for water on the 5th, is the 6th the date that would be? It's certainly one we could do. Is it the 6th the date that other people could do? It might be easier for you because you'll be in the neighbourhood, so to speak.
Yeah, we're all going to try and be as flexible as possible.
So we can do that.
We don't want to be a constraint.
We can do that, yeah.
Council?
Sorry, the 2nd June wouldn't work for...
And the 6th?
No, that wouldn't work either.
Any alternative dates that the Council would like to put forward for residential amenity site visits?
The Council's email of the 9th January sets out the availability for the witness that will be dealing with that, and it's the week beginning the 8th May, week beginning the 15th May, week beginning the 12th June, the 19th to 21st June, and the week beginning the 26th June are the dates.
If Knockcronal, I mean, I speak for others, but if Knockcronal was starting on the Tuesday, I think that's what Mr. Fraser was suggesting. That's the 13th. That would leave the Monday, the 12th, then.
We can pencil that in on the 12th with the proviso that it could spread into 2 days and we might have to find another day somewhere else. But let's pencil that in. With all of these dates, we'll take a view on the matter when we're writing the note. But it looks as if these dates are all broadly agreed. So we've added in the 12th of June for residential amenity. We don't have a date for the evening community event as yet, unless anyone would like to suggest it. Ideally, it would be at a time where there's a likelihood of the specialists of the three applicants with regard to landscape matters present, but not necessarily all their specialists. But is there any thoughts between the applicants what date that would suit?
If I could just jump in, sorry, while you're having a think. Again, on the basis of what I just said about things after the 29th of May, I'm wondering whether the evening of the 1st of June after the policy hearing, because, again, people will be in the area, and then you can...
Yes, I think that's a good idea.
Yeah.
Well, if the idea is that my landscape witness would be part of it, we can't do that.
It would really be a matter for the applicants who attended that. We wouldn't be requiring any particular specialist, but that would be a matter for yourself. But it would seem logical to have it around the time that we're having landscape and visual matters. I'm quite happy to leave that as a requirement to sort out through further written submissions to clarify the date, because I think we've possibly got to the point where we've agreed everything that we can agree today, but we have agreed that we will host one. The key thing is just finding the right date for that, and we'll reflect that in the minute. Very quickly, in terms of the order of evidence, not going to the details, but I just wanted to check with the applicants that the applicants were happy that we just follow it in numerical order 4, 5, 6, and the Craiginmoddie project based on this timetable going first anyway. So that would be the order through the hearings and such like, just to be consistent. If we've got any site-specific matters in hearings, we'd just deal with it on that basis. Does that sound reasonable from the Council and other parties? Yep, okay. And then the evidence from the Council and then other parties would come after that. But I just wanted to check with the applicants that order was fine. It doesn't look as if it will happen, but I'm not anticipating any friendly cross-examination. I don't think there's any plans from the applicants to cross-examine each other. Am I correct in that?
Subject to something unexpected not coming up, sir, but obviously there isn't any intention.
No intention at this point. We may take a photograph of these dates that you've got, just so we have the exact dates before we leave.
But I'll write it out in as neat a handwriting as I can muster.
That's lovely. As long as everyone else trusts that there's no other messages being passed, then we'll accept that. Item 9, very quickly, we've flagged up that we plan to carry out extensive unaccompanied site inspections. We've clarified this, the accompanied ones we're going to do on private water supplies and residential visual amenities. Subject to any particular access problems that you think might arise, we plan to do all others unaccompanied, and no need to set aside dates to have a general site visit. Nature Scott.
Thank you, sir. If I could just note again, so as it's not lost sight of, Nature Scott would be grateful if you could visit sites which they will suggest within the Merrick wildland area, and we'll be happy to provide suggested sites for you.
If any of the parties have got any particular strong views on where we should go to, then we're happy to consider it. No guarantee we're going to go, but we'll certainly consider it. So we'll offer that in the minute of the note to all the parties. We do plan to have an extensive itinerary, but if you're happy that you leave that to us, then that's great. It doesn't look as if there's any access constraints anyway, so that's fine. So I think that deals with site inspections. In terms of document management, this is a very complex matter with a conjoined inquiry, but I'm going to hand over to Mr. Reid actually. Just take us through what we expect will happen.
Okay, thank you. Document management is obviously a very important part of the inquiry. The main parties will know what a document is, but a document really covers any report, plan, photograph that anybody intends to rely on in their evidence. And I would ask people to think carefully about what documents they do provide, that they are ones that they're going to rely on, rather than just putting documents in just in case they're required. The applicants have been asked to compile a core documents list for all three applications, which will contain hyperlinks for those relevant documents that are already held by DPA, either as part of the renewables library or as part of the case file. So this will allow easy access to all the core documents for all the parties. So it's to make sure everybody has easy access to all the documents. As part of this process, the three applicants were requested to agree a topic structure that can be used again by all parties and to identify a single point of contact on their behalf for the purposes of building the document list. They were sent links to the renewables library and a list of case documents also. No separate copies of those documents that are already held by the DPA need to be provided. Try that again. Okay, we'll pick up where I left off. It's important just to stress that as the documents are already there and available to people, there's no requirements for separate documents to be provided that we've already got. So everybody has access to everything that's there. Can one of the applicants, I don't know if you've delegated the task to an individual, update on any progress made on this matter in terms of structure and topics? Nope, nobody's. Mr. Innes.
Sir, if it helps, we're aware of the issue, and we have just discussed in general terms the degree of cooperation, but we probably need to post this meeting. We're much clearer on what processes and procedures and processes are being adopted, and I think it's probably for the applicants and the council to come up with a structure that works and makes it accessible for all and makes it easy for documents for specific sessions to be identified and worked through. That does require a bit of forward planning, and I think we'll take some of the examples of some of the previous inquiries and try and make it as easy as possible to identify what's a core document, a session document, etc., to try and make it as easy as possible for everyone to access the material relevant to various sessions.
Okay, that would be much appreciated. As I say, having a clear structure allows everybody access to those documents. Just to say that any documents that aren't already held on the DPA library should be submitted in the usual manner to ourselves, and they will then be uploaded and available for everybody. Just to make it clear, once all the core documents are gathered, DPA will provide all the documents on USB drives, which will be encrypted drives, and these will be provided to every participating party. So you will be given all the core documents on a USB so you can access them via your laptop. They'll be distributed once precognitions have been received and processed, and the DPA case officers will do that, and they will be issued, as I said, to each individual party. Does anybody have any questions on that particular matter? No. Okay.
Okay, and we'll set a timetable for those documents in the minute, and timetabling is the next item, which is item 11, and we're actually just going to ask for your patience. We're going to pause for 5 minutes because we had a draft set of timetable in terms of the submission of documents and further written submissions and such. I would just like to check that based on what we've heard in terms of sessions. So it won't take long, but 5 minutes. So a 5-minute break until past. You don't need to leave the room or anything. It's just for ourselves to have a bit of a conflab. Thank you. I think we've got a set of dates. We just had to adjust there, which I'll read out, and we'll obviously capture this in our note. If any of these dates seem unreasonable, then we can have a discussion just now. As I indicated earlier, it is a very tight timescale to get to inquiry, but I detect enthusiasm to get to the inquiry before the summer holidays at least. We will issue the note within 7 days, by the 17th. If we're earlier than that, all good and well. We would commence the written submissions then, because they'll be specified in the note. We would aim to complete those written submissions within a month, so allowing probably 14 days and then a further 14 days. So completing the first set of written submissions, hopefully by the 17th of February. That's when we would expect a draft set of conditions to start to appear in terms of what we set out in our procedure notice. In terms of any statements of agreement that we specify in our note, or you voluntarily submit, then we're talking about the 8th of March for that. That's probably a reasonable time to look for a finalised draft of the core documents, to try and put that to bed in terms of the structure and the core documents. We would propose, and we can discuss it later, that we have a quick virtual meeting around the 24th of March, around that week, because things may change, and we think it would be useful to pencil in a virtual second PEM in a sense. It certainly won't be as long as this one, I don't think, but it's just to double check, because there's a couple of uncertainties. I think it would be useful to schedule that in, and it looks as if there's agreement from that around the table. So that's the date we've penciled in for that. Inquiry reports and hearing statements, we're suggesting the 31st of March. All documents to be done and dusted and finalised, and the list all sorted by the 14th of April. Precognitions the 21st of April. Hearing agendas and an inquiry timetable and programme finalised by the 25th of April, and then the hearing starts at the oral session start at the beginning of May, as we have agreed earlier. We'll agree at the end of the inquiry process the closing submissions dates, but generally speaking, would like to wrap the closing submissions within 28 days afterwards. So we'd hope to have the applicants' closing submissions as the last submissions a month after the last oral session. The additional information that we discussed that we would request as part of for the purposes of the inquiry, which is the cumulative baseline, an update and assessment, and the photo montages for the residential private visual amenity. We're proposing at the moment that would be the 8th of March that's completed. So we have that in good time. And we accept at this moment in time that there is scope for the two publicly advertised additional information that we discussed early, one from Craiginmoddie and one from Carrick, to run parallel to that. But we may have to take stock as we move forward. We hope it doesn't impinge on or doesn't prejudice anyone as far as the inquiry is concerned or hearings are concerned based on what you've said already. So we're happy just now to kind of run that concurrent and not seek to assist the process at any time. But that will be dependent upon both applicants moving on that fairly quickly and getting things moving as quickly as possible and advertised and ideally completed probably before the inquiry reports are completed. But is everyone content with that broad, well, it's not, it's quite specific actually, timetable? Is there anything that's frightening anyone there? The applicants all seem to be delighted with a tight schedule. From the Council's point of view, yeah.
So could you just briefly clarify, 31st March was documents, is that correct? And inquiry reports?
Inquiry reports and hearing statements.
Inquiry reports and hearing statements.
I had mentioned documents twice for an initial draft, worked up from the version we've already said to the 8th of March, and then finalised and put to bed by the 14th of April for documents.
And I've also got one further matter which I wish to raise at this stage, and it relates to Mrs. Crosswaite earlier today, and she's not here now, so I just want to flag that it appeared that she had a number of points she wanted to make, or was making, in relation to the noise assessments that have been undertaken by the various applicants. I mean, in relation to my own scheme, the noise section of Save Straighten for Scotland's submission was relatively brief and referenced certain further reports that might have been taken into account, but there isn't a lot of detail. And given the nature of noise, it might be helpful in the further written submissions that if Save Straighten have issues with the assessments, that they've got to really be fairly candid up front with what those are. And that's why I was seeking clarification as to what was happening in terms of the document exchange, because it's rather late if we actually get a full detailed noise report from an independent consultant on the 14th of April, and are supposed to respond with it with precognitions in a week. So I think there needs to be further opportunities for them to perhaps set out what their position is, so that we can respond to that in our evidence. And I just say that, I mean, we've set out our evidence in the environmental reports that have been submitted, and clearly there were matters of interest that she wanted to raise and had appointed an independent expert, but there is no real detail in the objection as to the nature and specification of that. And I do think that fair notice and making sure we have adequate time to consider those matters is important in the process.
Does anyone from Save Straighten like to kind of respond to that?
think, well, my understanding was, and correct me if I'm wrong, but is not the purpose of the inquiry reports, precognitions, etc., is that not where you set out what it is you're concerned about? We have taken on board Mrs. Crosswaite and her team relatively recently, and I don't think there will be any particular difficulty in providing the information that Mr. Innes requires. But I'm a little bit concerned that when Mr. Innes has a full-time team at his disposal and we're doing it on an amateur basis, that he's concerned we're going to outwit him in some way.
What, after hearing both of those submissions, I think there is scope that we carry out some further written procedures on the scope of the hearing or inquiry session, and I think that will assist both or all parties to consider what should be the scope of that oral session, and therefore that will inform the parties what to expect at that session. I think that should be able to address so that we wouldn't anticipate a party to come to a hearing and present evidence that wasn't within the scope that was agreed. So I think we could do that through an exchange between the relevant parties that are taking part in that particular oral session to hone in and nail down the scope. Does that seem reasonable, Mr. Innes, and for Safe Trading?
So I'm entirely content with that approach, and I think it's a fair one, and it does set the parameters for the subsequent hearing. So I entirely agree with the approach. Thank you, sir.
I think it is Mrs. Crosswaite's intention to write to the reporters within the next few days, setting out why she was requesting an inquiry session rather than a hearing session. And I'm sure if it would help, she will be able to give you further information on precisely which areas she wishes to cover in her submissions.
I mean, we're not asking any of the parties to provide any sort of additional guidance to us. We've heard what all the parties have said today, and we'll make our conclusions on that particular matter. I can't constrain any correspondence that comes to us, but once we've come to that conclusion, the likelihood is that we'll pursue that conclusion. We do have to move fairly rapidly because we have to agree the process, agree the timetable, and set things in motion. So once we have concluded in the note, the likelihood is that there'll be limited scope. We have timetabled another examination meeting, pre-examination meeting, which these sorts of things could be discussed if there was any significant changes or any timetabling issues. But I'm not asking for any of the parties to submit any additional correspondence beyond today, other than the things that we've agreed. Perhaps just a note on precognitions, just to be clear, everyone providing evidence at an inquiry session would be required to submit a precognition in advance, and we've agreed the dates. They should be concise, cross-reference to other documents, don't include too many appendices, in fact no appendices or technical information. That should all be either in the documents you've lodged or in the inquiry report. And I think we would probably try to aim for a 2,000 word limit as well. Please put paragraph numbers and page numbers in your precognitions as well. I'm sure you all will. But it's really useful for all parties if we do that. Also, we would propose on inquiry sessions to take precognitions as read, and not ask the parties to read out their precognitions. You may wish to take your witness to certain paragraphs, but we're really not looking for the whole precognition to be read out. Is that agreed from the applicants? The council happy with that? All other parties happy with that? It's just so we can save a bit of time. In terms of the documents, most will know this, but ideally submitted in a Word or PDF format. If there's exceptionally large documents in terms of physical size, then we might require plans in paper format, but hopefully everything will be electronic. Item 12, now we are getting towards the end, and I think we will hit 4 o'clock. Certainly won't hit 1 o'clock. It's been recent practice that as part of the closing submissions, we would ask the parties to provide a summary of their case, not containing new evidence, but we'll attach a template to the note of this meeting, which explains that, and I'll explain that within the note. It's only for the matters that are at inquiry that we'll ask that. We're likely to tailor the templates to this inquiry, and we're looking for a fairly succinct summary of case from all the parties. So just to flag that up just now, this will happen at the very end of the process, but we'll ask you to complete a fairly succinct statement of case based on our broad guidance, so that we can hopefully slot that into our reports to ministers. I've mentioned that the order of the closing submissions would be those making representations in the council would make their submissions first, and then the applicants thereafter, and hopefully all done within 28 days. Each party should send the other parties their closing statements, and we'll post them on our website. Is there any further questions on the likes of the precognitions, or any closing submissions, or those summaries, the templates that I've highlighted that we will use? Everyone's quite content with that? Yep. Okay. Very quickly, item 13. Essentially, in the note, we'll provide a contact for you for any particular reason you need to contact the DPA. Then it's Morrigan, Chris, and we'll provide those contact details, emails in the note of the meeting. As we have indicated, the note of the meeting will reflect our final conclusions after reflecting on what has been said today. We've agreed a lot. There's a couple of things that we've got to consider, but that will reflect, if you like, our intentions for the procedures. It will, in a sense, be a formal procedure notice, and in terms of written submissions, we'll set dates and be definitive about what we're asking for, and we'll set out everything else that we agreed today in that note. It'll be sent to all the parties that have opted in and have attended today, and hopefully within 7 days, if not before. I didn't see anyone objecting to a second PEM as long as it's virtual. I just want to double check that now, and you're all happy with the date of the 24th of March. So we'll put that in the...
I think we may have to just check on the dates, but can we get back to you on that?
What we'll do is we'll put that in as a provisional date, and then if there's any concerns about that, then we'll probably give you 7 days to get back to us.
Okay.
And we'll record that in the note.
I'd understood you to say that was about the 24th. If it's the 24th, I can't do that.
So we'll say that week. And in fact, we'll propose another. We'll look at our diaries again and the webcasting diary to see if another date is possible. Are you free on the 25th?
25th is Saturday.
Or 25th is Saturday, okay.
Well, I've got
23rd?
I have an inquiry all that week, but there could be somebody else that does it. If it's just going to be a sweep up of procedural matters, there'll be somebody else that I can call on.
Okay. So I think in terms of the timetable, we'd like to do it in that week because it fits in with the rest of the timetabling.
Okay, I think Mr. McGivern's telling me the 25th is a Saturday, actually, sir, so it would probably have to be earlier in that week. But
yeah, Mrs. Levin informed me on that. I'm not asking you to appear on a Saturday, nor a Friday night. So we'll work back from the 24th. Ideally,
Good. I don't know whether people. That's the 20th.
Sorry, the Monday wouldn't work for me, but any other day that week would work. But the Monday wouldn't work.
Yeah. And actually for our webcasting, for our virtual technology, the staff are engaged at the beginning of the week, so it would have to be Wednesday, Thursday or Friday that week, actually. So the Wednesday or the Thursday?
As I said, I'm in an inquiry, but we'll cover it. I don't want to give the reason that it doesn't take place.
Okay. So I think we'll stick with the 24th then, if that's...
As long as we can come back to you if there's a problem, sir. Need to go and check.
Yeah. Okay, provisional date 24th, subject to any further submissions on that. In terms of timing for starting, I know it's getting towards the end of the day, but useful just to kind of run through these things on a daily programme. If an in-person inquiry, happy to start on the first day at 10 o'clock, then 9:30 thereafter. Happy with that, everyone? Aim to finish about 4:30 with an hour for lunch. Does that sound about reasonable? Okay. In terms of virtual process, we would suggest maybe a 10 o'clock start, 4 o'clock finish, less screen time. Does that seem all reasonable for the virtual processes? And again, we might be able to allow a shorter period for lunch since it's virtual.
Unless I've missed something in terms of the physical venue, is that here?
Well, I was going to come on to that, but since you've raised it, but as well to discuss it now, is that we would normally ask the council if they can come up with a venue. They have done for today's meeting. We'd be very happy, subject to availability, if this was the venue. But does anyone have any strong feelings on that?
So I think overall the venue seems good. The only question I do have is we may be short of electrical plugs. I don't know whether some thought might be given as to whether we can expand on the number of outlets, so to speak. But otherwise, it does seem a good location. So.
Is everyone happy that the in-person could happen here, subject to availability? Does this suit those locally? Is it a reasonable venue? Yeah. We haven't checked availability yet because we didn't know which dates we're talking about. The room is available during the week. It would have to be cleared up before the weekend, we understand that. And there may be flexibility around moving anything that's in here in the evening to another hall. So there could be the ability to keep all our kit in here for a week or so, or during the week. So we have investigated that. Failing that, we will go back to the council and ask if there's an alternative venue. I think you've suggested one already, but if everyone's happy that we investigate this look as the venue, then we'll do that. If any party is considering making any legal submissions of any way that could affect the running of the hearing or the inquiry, please lodge them as soon as possible. Don't wait until the start of an inquiry or a hearing. So any delay in any legal submissions would be certainly contrary to the spirit of prior disclosure, and would be very wasteful in terms of inquiry time and unfair on the partners. So parties. So I'm not anticipating, from what I've heard so far, any legal submissions from any parties. But please don't hide those things away. If there's any particular legal submissions that you'd like to make, then they should be made as soon as is possible. But I'm not expecting any, from what I've heard today. And no one's putting their light on or flashing things up. So we're not expecting any challenges to the process or procedures or any legal matters to be brought in front of us. That's good. Mrs. Leven or Mr. Reid, is there anything that I've missed that you would like to flag up before I open to the floor? And is there anything else that any of the parties would like to mention, or are you exhausted? Okay. We'll proceed to finalise the note of the meeting. We will... A couple of reminders. One for Safe Straighten to get that information on the properties, the 7 properties, and the location of them to us. Ideally, by the end of the week, so that we can actually consider that and come to a conclusion in our note. I think you've agreed to that anyway. We'll give 7 days after we issue the note for parties to indicate whether they're going to participate in things or not. They may have second thoughts on participating, and there are a number of parties who said they were going to be here today or have opted into the process that haven't been able to be because they've not been here to say. So we're giving them 7 days to indicate. For example, Nats would be one group. So we'll give the parties 7 days to confirm their participation in the procedures. And we'll probably ask, actually, within those 7 days, just for the names of the witnesses and such like, rather than going through it today. And as soon as possible, I think the Council were going to provide the site visit information for the private water supplies. So if you can provide that as well. I think that's all my kind of wrap-up matters. Thank you very much for bearing with us today, and we look forward to seeing you at a future date, whether that's on a screen or in person. But I think as far as we're concerned, that's the meeting closed. Thank you.